Good, good morning. Good morning. I'd like to call this public hearing of the Judiciary Committee to order. We have a couple of people signed up to talk to us about the issues on the agenda today. We are going to begin with number one. Are there any comments from my co-chair?
Mr. Chair, just real quick, remind folks, this is our first formal public hearing on bills. So just so folks know the rules of the road, you get 3 minutes to testify. The bell will sound. That means you're done, not start thinking about being done. So it's 3 minutes. And if there are questions from the committee, we'll entertain questions after that.
Thank you. And we'll try to be nice about reminding you that your 3 minutes are up. We'll try. All right. So we're going to go right into it, starting with number one, Magdalena Coleman. If Magdalena Coleman is here, you may testify.
Recording in progress.
Okay. Sorry about that. Stephanie Thomas, the Secretary of State.
Sorry, good morning. Co-chairs Winfield, Staffstrom, ranking members Kissel, Fishbein, and members of the committee. I'm happy to be here this morning. Connecticut is one of only 8 states that does not have a permanent remote notarization law. So we are happy that the committee is considering codifying these services in Connecticut. I'm joined by my colleague, Chris Drake, the director of our business services, who has a lot more details about the bill and can answer questions. But before I turn the microphone over to him, I'd like to bring up a few specifics about SB 1040 and HB 6713. 1040 seems like it's trying to codify Governor Lamont's Executive Order 7Q, which was permitted during the pandemic. And I just wanted to make note that although my predecessor supported this policy, and I believe was correct to do so during the pandemic, it was never intended to be permanent. You have our written testimony, but I wanted to note that we are currently not aware of any other state that is actively considering adopting this method because there are more secure and better methods available. And just briefly regarding HB 6713, we're generally supportive of this bill, but have a couple of reservations. I believe sections 15J and 15K go against what I believe the goal of the bill to be, which is to make remote notarization more widely available and convenient for the public. We also want to be sure that the committee understands that the bill as currently written will increase the time and cost to become a notary and also would require new regulations. So irregardless of the effective date that is currently being contemplated, remote notarization would not actually be possible until the regulations are written and the state's e-license system is reconfigured. I'm going to turn over the rest of my time to Mr. Drake, but I will still be here to help answer questions.
Good morning, committee, and I understand I have about 45 seconds left. The secretary nailed it. There are 2 bills about remote notarization, SB 1040 and HB 6713. 6713 is closer to what we think is best practices for remote notarization. That is adopting the revised Uniform Law and Notarial Acts. There are 2 problematic sections in there that we noted in our written testimony, section 15J and 15K, exempting out certain documents from remote notarization. And with respect to Senate Bill 1040, that is adopting an older process called remote ink notarization, where the notarization is done on paper and then mailed back and forth between the notary and the signer. That said, if that is the vehicle that where we could achieve remote notarization in Connecticut, our office is happy to work with the insurance association on some revised language. And I'll take any questions that you might have.
Thank you. Representative Fishbone.
Thank you, Mr. Chairman. First of all, good morning, Madam Secretary. I think you still owe me pizza from last session, yeah. You came into my district during the election and I was gonna appear at that event with a pizza, but I thought I might have got thrown out. But anyway,
Next time.
not by you. I just had some I gotta tell you, 6713 scares me. And your objection, although you didn't state, J and K have to do with opening this up to wills, trusts, certain testamentary documents. Which, being someone who who's done a good number of cases on undue influence and those kinds of things, and the probate context, the family court context, I got to tell you, I got a lot of problems. And the other K has to do with real estate documents, which, opens up concerns as well. But I just wanted to ask about two particular portions of 6713. And I don't know which of you would have the acumen to address, but section 4 says that if the process isn't followed, that the document is voidable. What is the procedure by which one ascertains or attempts to make that thing voidable?
Sure. So we get some variation on this question quite a bit. We license notaries public. We don't license any of the other professions that are otherwise given the authority under Connecticut state law to do acknowledgements and attestations. So when the actual attack is on the document itself, that something about it was either fraudulent or there was undue influence, or we always push that question back to the court system that is better off answering whether the contract or the will or the particular document itself is viable. We can opine on whether the notarial act itself was proper, but typically in those cases, it's very difficult for the notary to determine whether the person who signed it was under undue influence. So it's going to be like a very fact-specific inquiry to determine whether, the person was of sound mind or whether they were under a substance at the time that they signed the document. So those sort of things. So my position would be that that is for a probate court or a superior court judge to make.
Okay, so you would agree with me, there is no procedure in this 35-page act by which one is supposed to follow to determine that it's void.
I think the only thing that this bill would change is that there are other options available to notarize that document. And so a court would have to determine whether the procedures laid out in this bill were followed in that particular instance. But the inquiry would be largely the same as an inquiry right now under in-person notarization. So you would, the standard facts that the judge would need to ascertain to determine whether someone signed the document voluntarily or under coercion.
So, I have familiarization, through the pandemic with a lot of court proceedings done remotely. And in many of those matters, to the judge's credit, he or she has asked whether or not there's someone else in the room. Many times, asking the individual if they have a phone or a laptop to pan the room to make sure. Is there a provision of this that would provide for that requirement if it's like, let's say, a will, which you're advocating?
So not in the bill, to my knowledge. What I've seen from other states that have done implementation regulations is they have addressed that. That is something that we also address in our current notary manual, about whether we tell notaries that if you have any suspicion that this person is not executing this document voluntarily, that you need to ask the person questions about what they are about to do, whether they understand the consequences of their actions, whether they understand the substance of the document. So for remote notarizations, that would be typically something you would put in a regulation to advise notaries public that that is part of a standard question that you would want to ask them: who's in the room, why are they in the room, that sort of thing.
And you would get that done through the regulation process that you admit is not complete at this point.
Right. As the secretary mentioned, that the way this bill is set up, you really can't do a remote notarization without our regulations being in place, because we have to stand up the regulatory framework. There's two big hurdles. First, we have to approve remote notarization vendors in Connecticut. So we have to authorize particular software to be used in the state of Connecticut. So that's like step one. And then step two is that a notary who wants to offer remote notarizations has to sign up with us or register with us as a remote notary. This is completely anecdotal evidence, but just talking to my colleagues in other states, I think there's some impression that remote notarization now becomes like the de facto way to do things. And other states that have done remote notarization, it's actually a fairly small percentage of the of the notarizations done. So somewhere in the neighborhood of about 5% of the notaries in states sign up to be remote notaries. So my educated guess would be that even if this bill were to pass, the vast majority of notarizations done in Connecticut for the foreseeable future would be our traditional in-person notarization.
And I do recognize in reading the backup, your testimony, your written testimony, that there is a distinction between lawyers who commission Superior Court and notaries and the requirements. I will represent that I am a notary also. So, I hold both hats. So I have knowledge in both areas. But moving on to section, it's section 5, parent D. And I only have one more section after this, just so that you know. I'm trying to figure out, I only notarize or sign off on a document that's an original. It appears that this would provide for signing off on a copy. Let me just read. A notarial officer who certifies or attests a copy of a record or an item that was copied shall determine the copy is a full, true, and accurate transcription or reproduction of the record or item. So what does that apply to?
Sitting here right now, I can't really answer that. I know that under our current, so there was a modification made to our current law several years ago to allow notaries to make true and attested copies so that they could, but you're pointing out a section that doesn't appear to be related to that the notary would actually be notarizing the copy itself. So I think we'll have to take that one back.
Okay,
'Cause
thank you. I look forward to hearing further on that. And then lastly, section 6. I don't understand. And I want to just read that so that everybody can follow along. Except as provided in section 15 of this act, if a notarial act relates to a statement made in or a signature executed on a record, the individual making the statement or executing the signature shall appear personally before the notarial officer. So this appears to be a requirement that it is not remote notarization. And I reviewed section 15 and I'm trying to figure out how the two work together. If you could explain.
So that's I think relating to depositions. So that's always been a little bit unclear under current Connecticut law. Technically, notaries are provided the legal authority to take depositions. We advise notaries strongly not to do that because we think that is far better done by a licensed attorney. So it otherwise says that that if you're taking a statement on the record, that you have to do so in person unless you follow section 15, which section 15 is the one that lays out all the standards for remote notarization. So it's sworn testimony under where the person who is executing the document is also providing sworn testimony.
Okay, but depositions are done remotely too. I have done them. So how does section 6 deal with depositions?
Because they have to be done so it's basically saying like the default rule in Connecticut is that notarizations are done in person, except as provided by section 15. And section 15 lays out how you do a remote notarization.
Okay, so it doesn't specifically apply to deposition. It applies to all acts that are not in conformance with the requirements of section 15. Is that?
It appears so, yes.
Okay. I will say I am in favor with apprehension of 1040. But this scares me. So with that, I thank you, Mr. Chairman, for the opportunity.
Thank you, Representative. Comments, questions from members of the committee? Representative Doucette.
Thank you, Mr. Chair. And thank you, Chris and Madam Secretary. Sorry, I can't really see over you guys.
Also blinding.
Chris, we've discussed this quite a bit over the years, and Madam Secretary, I know you may be relatively new to this, but it's good to have you in on the conversation as well. And, the conversations in years past took place in the Commerce Committee. I happen to think that, I guess from my perspective, this is a more appropriate venue. Obviously, it deals with the uniform law, but also, and you mentioned, as a policy matter, what we're looking to do is to make notarizations more convenient and widely available to people. And, certainly I don't disagree with that as one of the policy goals of what we're doing here. But like everything else, it's a balancing act, and certainly a consideration here before this committee is addressing what may be, compared to some other states that have adopted Rulona, sort of the quirkiness, if you will, of Connecticut and the role that attorneys play, particularly in real estate, especially in wills and trusts. We are in many respects a strong, attorney state, especially for those real estate transactions. So I think that is the whole point of 15J and 15K, I believe it is. And I don't think we avoid, having to balance those considerations. I don't think there's any other way to do this. So I guess if you could just, answer me, you have sort of, I guess your position is you do not support or oppose, but it sounds like you mostly oppose the way 15J and 15K are drafted. Again, I understand you stated earlier that, the policy is to make notarizations more convenient and widely available, but I guess I would caution that going too far in the other direction on that policy, I think goes too far in the other direction of trying to find that right balance. Again, on the Commerce Committee, I think we also, and I know there was a task force set up by your predecessor, Madam Secretary. There were some of the technology companies involved in that as well. So I think there was, it was more slanted in the policy consideration of convenience. And I think, again, when you go too far in that direction, I think when we're talking about purely talking about the technology and adapting the technology, that we lose sight of some of the things that attorneys do here in Connecticut, which again may be a little different than other states. So I guess I'd just ask you to expound a little on 15J and 15K and what your concerns are with those sections.
Thanks, Representative. So the major concern is that it's a fairly significant deviation from the Model Act. So it exempts out some of the some of the most popular transactions that need to be notarized. So your real estate conveyances, your wills, your trusts. But in and of itself, like the legislature, if the legislature wants to pass that policy, that's a workable exception. I was briefly before the committee started reading the testimony from Notarize, which obviously has a vested interest in the outcome because they're a vendor of remote notarization software. But I thought they did raise a point that was valid in that we do have other laws on the books that require interstate recognition of notarial acts. So for instance, Nevada was one of the first states to adopt a remote notarization law. Currently, if someone goes online and uses a Nevada notary to remotely notarize a Connecticut document, we have another set of laws that say we need to give full faith and credit to that notarization. So while you could exempt out Connecticut notaries from doing those transactions, I think it's a little bit dicier whether the Connecticut legislature has the authority to exempt out other states' notaries from notarizing those documents. And we may be getting into territory that starts to butt up against the full faith and credit clause in the Constitution that, you know, we have to give full faith and credit to other states' laws. And I think that in some regard that is already happening, that people who want to do remote notarization just go online and find a Texas notary or a Nevada notary. So if there was a particular concern about real estate documents and wills and trusts, I think you could very clearly exempt out those transactions. It's a little less clear to me sitting right here that whether we could say that, and we won't grant other states who do that validity of those notarizations done out of state.
Right. And that's a fair point. And I reviewed that testimony from Notarize. Again, they do have a vested interest for sure. I'd agree with you on that. I do want to take another look at that. I'm not sure they're 100% on, but if we do need to, revise that interstate recognition, then certainly we need to do that. I guess my point, and I'll conclude here, is, those transactions, if done in another state, and if done with someone shopping, a notary in another state, would amount to the unauthorized practice of law in many cases. So I think that's certainly a concern here, and that's within the cognizance of this committee, and is a concern of mine. So we have to find a way to balance those considerations. So that's continues to be my concern. Thank you, Mr. Chair.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Senator Representative Osborne, sorry.
Giving me a promotion after just 2 months in the legislature.
You all usually don't call it that, but yes.
Oh, now I'm in trouble with my own caucus. So thank you very much for being here today. As an attorney with a very small private practice, I represent individuals in my community, and I do a lot of family law work. And I can say that the remote notary ability during the pandemic, it really enabled us to keep serving our clients and keep moving our cases forward when the courts finally reopened. For me, the provisions of 1040 worked well, to the extent that they are akin to what we did at the time. They did work well for the types of clients and this, the small cases that we do. Can you expand a little more on your objections to 1040 and why you view it as problematic?
Sure. So 1040 is what we in the notary business called remote ink notarization. It is essentially what Governor Lamont authorized during the pandemic. So it's essentially a traditional notarization, but where the in-person part is done via Zoom or Teams or whatever. So the person's actually signing a piece of paper and then mailing it or FedExing it to the notary. The notary is putting their notarization stamp and seal on it and then sending it back to the person. So for all intents and purposes, it's an in-person notarization with the caveat being that the notary and the signer weren't in the same room when the execution happened. There's two major problems with it. One, ID verification is even more difficult in those scenarios. So you basically have a scenario where if the notary doesn't know the person, they have to hold their driver's license and then a second form of ID up to the camera, and the notary needs to kind of check to see whether obviously that problem doesn't occur if the notary personally knows the person. So for instance, in your case, if you personally already knew your clients, then you wouldn't have to go through that ID verification part. The second point is on the document itself, because it's difficult for the notary to ascertain whether the document they received in the mail is actually the unedited version of what the person signed before, because in a traditional notarization, the notary's witnessing the person put their hand to the document. So those are the two primary objections. But it did work out relatively well during COVID. I think the order was in place for about 18-20 months, and we did hear relatively good feedback on it. I know the town clerks had some open questions about recording real estate conveyances, but otherwise it worked out pretty well, all things considered.
Through you, Mr. Chair. But you wouldn't object. So for instance, in the practice that I have, there really are no such thing as original signatures anymore. It's all done by scanning. It's scanned back and forth between, final agreements are getting filed in Superior Court with no original ink going in because everything is e-file now. Would you object to that limited practice continuing with respect to a remote notarization of those scanned signatures?
My recollection is that is specifically one of the sticky issues that the town clerks raised during the executive order being in place, that it would be proper for the notary to notarize a copy of the document, but what the town clerks were looking for in those towns that don't do e-recording was the original notarization itself. And sometimes they weren't finding it, and so they weren't sure whether they were supposed to record it or not. I mean, these are issues that can get worked out. I also think there's an open question. There was an older, but predating Rulona, there was an older law about in-person electronic notarization. It's just a mess of acronyms. So that is, would it be proper for the notary to execute the document digitally, or the signer to execute the document? Do they really need to sign the piece of paper, or can they apply some sort of digital signature to it? That's not currently in what is it, 1040, but it might be, if we were to do a revised version of that might be something to consider to make it easier for clients and notaries themselves, that they could have used some sort of document signing technology to sign the document rather than mail it back and forth.
Thank you. Thank you, Mr. Chair.
Thank you, thank you, Representative. Comment or question from members of the committee? Comment or question, Representative Fishbone, for the second time.
Thank you, Mr. Chairman. I just, going back to the land record situation, now you remind me, I had a case about a year ago that I ended up getting out of, and it involved leases and promissory notes and that kind of stuff. And one of the reasons why I got out was I compared the signatures, and it appeared that there were cutting and pasting going on both sides. And I just didn't want to be part of that whole situation. That's the stuff, when you got the town clerks concerned about original signatures, and they're part of the gatekeeper function here. I'm supportive of that and their attempts to make sure that those documents are legitimate. I don't know how we deal with this going forward, but I think it's really, a lot of that stuff doesn't come up till like years later. Something's recorded in the land records, and then 20 years later, somebody says, this wasn't done right. It's difficult to prove, differently. I think we have to tread lightly here. So I thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us this morning. Next, we will hear from Brendan Faulkner.
Good morning.
Good morning.
Thank you, Mr. Chairman. Thank you, representatives. So I am here. I appreciate this opportunity, and I'm here to speak in opposition to SB 954, which is the insurance industry's attempt to legislatively overturn the Marciano decision. And there's a few things to note. It's essentially, this is a solution in search of a problem. And that is shown in part by the fact that the hospital association, as opposed to just the insurance industry, is supporting this bill so strongly. The hospital association claims that the proposed bill will correct a technical flaw in the general statutes regarding the reduction of collateral source payments, but there's no authority for the claim that there is a flaw. The very issue brought up by the proposed bill was at issue in Marciano, and all of these arguments were made, and the court made its unanimous decision that the statute means what it says. And so notably, it says there shall be no collateral source reduction where a right of subrogation exists. And so what the industry associations are asking the legislature to do now is to take away one part of a very complex statutory scheme that was heavily negotiated in 1986. And I don't think the Judiciary Committee wants to begin that undertaking for no particular reason other than the insurance industry asks for this year after year. So I wanted the Judiciary Committee to know that Marciano made absolutely no change to the existing law. It simply applied the plain language rule, which means that the courts apply the plain language of the statute as opposed to wondering or searching for what the intent may have been in 1986, as the defendant in Marciano was encouraging the court to do at both the trial and appellate levels.
Are you finished?
Yes, I'd be happy to answer any questions. Thank you.
Thank you very much for your testimony. Are there comments or questions from members of the committee? Comments or questions, Representative Blumenthal?
Thank you, Mr. Chair, and thank you for being with us today, Attorney Faulkner. I was wondering if you talk to us a bit more about the way that these sorts of bills are negotiated and why it might be fair or unfair for the benefit of that negotiation to go to the wrongdoer as opposed to the plaintiff who is injured.
Yeah. So yeah, exactly. There's absolutely no reason for, I mean, first of all, it doesn't occur often where there is a windfall, but there's absolutely no reason that a windfall should go to the defendant. The whole purpose of tort law is to deter bad conduct, and the defendant should not be the one that benefits from the injured party's good fortune of having whatever coverage it may be that's subject to the collateral source statutes.
Thank you. I appreciate that answer. And thank you, Mr. Chair.
Absolutely. You're welcome. Comments or questions from other members of the committee? Comment or question? If not, thank you, Attorney Faulkner, for joining us here in the Judiciary Committee. Next, we will hear from Judge Beverly Street Capalis. Good morning, Judge. You may testify once you're at the seat.
Good morning. I'm Beverly Strike Cafalis, the Probate Court Administrator. Thank you for the opportunity to testify, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and other members of the Judiciary Committee. I'm here this morning to offer comment on House Bill 6569, an act concerning the minimum age to be eligible to marry, as well as to support very specific provisions in House Bill 6713, an act adopting the Connecticut Revised Uniform Law and Notarial Acts. I have submitted written testimony on both matters, which will go into more detail than my 3 minutes may allow. Suffice it to say, with respect to House Bill 6569, I would call the Judiciary Committee's attention to the current statute regarding the issuance of a license to marry for a young person aged 16 to 17, which provides for a very different schematic under state law when it comes to protecting children. I would offer a comparison. Is a petition to emancipate a minor has substantive child protection measures that are absent from the current law with respect to a minor being eligible to marry. The 2017 Public Act did enhance some of those measures. There are specific factors a probate judge must adjudicate in order to grant them. But measures such as having independent court-appointed counsel for the minor are absent. There is no investigation of such a petition by the Department of Children and Families. And the overriding legal standard is whether or not the marriage would be detrimental, as opposed to the uniform standard for review of child protection matters is the best interest of the child. So I would ask the committee to consider those comparisons when it reviews the statute before you. House Bill 6713, an act concerning the Connecticut Revised Uniform Notarial Acts. I would specifically, respectfully disagree with the Secretary of the State with respect to the exclusion of specific documents set forth in Section 15J. And I would call to the committee attention a number of reasons for that. Specifically, I do think it's a very important deviation from the uniform law. As many of you may be aware, elder fraud and financial exploitation is on the rise. In fact, just since 2020, the losses have increased by 74%, and the number of elders age 60 and over, yes, we're old elder, I guess, these days if we're 60 or older, is also the number of victims and the magnitude of the losses on the rise. We're talking in excess of billions of dollars a year. Excluding estate, healthcare, and related planning documents from the provisions of remote notarization are critical to ensure proper execution of these critical life planning tools and an additional protective measure against exploitation. It is new technology, relatively speaking, and the bill is intended to provide appropriate safeguards for identifying the person signing that the role of the notary places. However, the particular remote notarization, especially in the domain of estate planning and healthcare directives, has not been vetted. I think Representative Fishbein a number of important issues that are important to the probate court system. And in essence, it may invite increased litigation over the proper execution of these critical documents. Most estate planning and healthcare directives are not really vetted until after an emergency arises, death has occurred many, many years after execution. The unique aspect of the remote notarization law provides that the audio video conferencing, for example, is retained for only 10 years. Typically, an individual executes these documents, and yet they're not reviewed or sought to be admitted into the probate court for many, many years later. So the evidence of the proper remote notarization isn't even available by the time these issues arise. I would also just call attention to the issue about the failure to use approved technology. There's disciplinary action that may be taken against the notary, but the documents themselves are voidable, again, inviting litigation, which we would discourage.
Thank you,
Thank you.
Judge. Representative Fishbaum.
Thank you, Mr. Chairman. Good morning, Judge.
Morning.
Nice to see you again. I just want to talk about the right to marry bill. I will tell you that in the system, your written testimony is not there. So I'm sure it'll get there. But anticipation of today, I wanted to know what you thought. So I'm glad that you're here. Since the law was passed, the revision, which went into place October 1 of 2017, how many times, if you know, has this been used?
I actually have statistics in my briefcase. I would say it is not a prevalent petition brought in the probate courts, but there are petitions every single year.
Okay, and do you know, like, just because it's a petition doesn't mean that it meets the, I think, very high burden that the statute presently has. Do you know how many times it's been effectuated since October 1 of 2017 in Connecticut?
In my last review of the actual petitions brought in the probate court, the vast majority of the petitions were granted. I have urged our probate judges that when they have these petitions for review, that they should at a minimum consider the appointment of a guardian ad litem to represent the interests of that minor. It is a petition not brought by the minor as opposed to in an emancipation petition. It is brought by a parent or a guardian. And I do think it's important, again, to distinguish significant measures that are in place for a petition for emancipation, again, which is brought by the minor, him or herself. There is no independent representation provided for in the statute in a petition for issuance of a marriage license for someone 16 or 17. There is no investigation by the Department of Children and Family. The petition seeks and provides for, by statute, factors a probate judge must determine, such as that the minor is voluntarily consenting and there is no coercion. The challenge in many of these proceedings, however, is there's no independent review or investigation of the factors leading to the petition. So at a minimum, the parallel, I believe, should be brought to the emancipation proceedings where those due process and child protective measures are at least in place.
So do the two run concurrent, meaning if a minor is emancipated, do they have to follow this procedure still?
You know, I can't say I'm as well versed on that parallel. My understanding in my recollection is that is a different proceeding.
Because when I look at the language, and I supported the language you did in 2017, it unanimously passed House and Senate. It does not, it talks about the age. It doesn't talk about the legal status of the individual. And that was a thought that I had. What if it is an emancipated minor? They would still be required to follow this process, which is fine. But now if we got rid of that, then an emancipated minor would not have the ability. Correct?
I believe that is correct. However, I think the vast majority of the petitions filed in the probate court do not involve an emancipated minor. These petitions are petitions brought by the parent or the guardian, not by the minor.
Because I know in the 2017 bill, we did also modify 46B 150D, which has to do with emancipated minors. So the way I read it, if this bill as presented was to pass, that an emancipated minor would not have that ability. Now, what about the situation where, you know, quite often a young man is, or woman, is going off in the military, going overseas, and I see a marriage just before that happens for various reasons. 18-year-olds, 17-year-olds, we're not going to get into sex acts or anything like that, but they have a relationship that is, they believe to be loving and should be forever. Should this law pass, there would be no ability to marry those two individuals, correct?
So to clarify my position, I am not taking a position in support or opposition. As the probate court administrator, the public policy that the committee should review is not something I take a position on. These matters come before the probate courts. And so if I were to support or oppose, I am in essence directing the probate judges on how they should adjudicate these matters. My role today really is to offer a comparison of similar statutes in child protective areas and offer the distinction between the petition to issue a marriage license and an emancipation, which is probably the closest parallel as our young individuals are approaching adulthood.
No, good answer. I appreciate that. But what I heard in your comments initially, I'm not trying to put you in a box, okay, is that if we added to the statute the additional requirement that the probate court appoint an attorney or a GAL at the probate court's expense, I think that would be of more solace to the process without you being a policymaker. Is that fair to say?
It's fair to say that a court-appointed attorney for a minor would have the role of advocating for that client who is a minor. And again, in the emancipation statutes, it expressly provides that that court-appointed attorney may also act as the guardian ad litem. What a guardian ad litem's role is to recommend to the court as well as to advocate the best interest of the child. Again, the distinction in this particular statutory scheme is not the best interest of the child, but rather whether or not the proposed marriage is detrimental. So it is a unique and different legal standard for review.
I appreciate that. And I know you had numbers in your briefcase. If you could perhaps get me those numbers, I'm really interested in learning how much of a crisis this situation is. So I thank you.
Happy to share that. Thank you.
Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Comment or question from members of the committee? Comment or question?
Well, just a quick comment in response to the ranking member's question. The chair may have an opinion on this as well, but those of us who have seen marriages immediately pre-deployment may have thoughts on whether they're advisable in the first place. And that's all I had to say.
I've seen plenty of them and I'm not commenting. Comment or question from members of the committee? Comment or question? Representative Fishbein. Sorry, Representative Stasham, I'm just.
All right, I think we need a recess. So let me just clarify. There was a question that Representative Fishbein asked you about emancipation. And so is it your read, if this statute passed as is, or this bill passed as is, would an emancipated minor be able to get married or not? Or it's not entirely clear?
I would have to review the specific emancipation statute before I can offer an answer to that question, which I would be happy to do after today's hearing.
Okay.
Thank you, Representative Stastrom. Thank you, Judge. I believe there are no further comments or questions. So thank you for joining us. Oh, well, there is one. Representative Osborne.
Thank you, Mr. Chair. And just to follow up on that, it's not just emancipated children who would be unable to marry under this bill. It would be pregnant 17-year-olds who have strong religious beliefs that having a child out of wedlock would be worse than the predicament that they're already in, they would also be prevented from marrying, correct?
Well, I can't comment on the characterization of those situations. However, if this bill as presented were to pass, it would prohibit marriage of anyone under the age of 18.
Including pregnant 17-year-olds, correct?
Yes, I believe the
Thank you.
the circumstances of the minor would not be relevant.
Thank you.
You're welcome.
Thank you, Representative. Comment or question from anyone else on the committee? Comment or question? This time there really are none. Thank you very much for joining us.
Thank you.
Jonathan Dobb from the Office of the Governor. Good morning. You may testify.
The honorable members of the Judiciary Committee, and thank you for raising 6569, an act concerning the minimum age to be eligible to marry, and for providing me an opportunity to be heard in support of that bill today. Before I continue, I want to be clear that I'm testifying today in my personal capacity and not on behalf of Governor Lamont. My name is Johnny Dopp, but it's not the name I want to leave you with. Instead, I ask you to consider Jasmine, Josephine, Lucia, Natasha, Maria, Nada, Janaya, Cheyenne, Maria, Jasmine, Victoria, Mayerly, Anna, Jamila, Catherine, Crystal, Erica, Asil, Afsana, Savannah, Jasmine, Lydia, Samantha, Beatrice, Journey, Amelie, Shema, Joaquim, Jaden, and Ian. To answer Representative Fishbein's earlier question, those are the 3 boys and nearly 30 girls, including 9 16-year-old girls, married as children, including to men in their late 20s, since Connecticut last considered whether to continue allowing child marriage in our state. They live in 21 different towns. You'll hear today from other witnesses who can explain more eloquently and personally than I can why the harmful practice of child marriage is, in the words of President Obama, a threat to fundamental human rights. What I want to share with you is that a vote for this bill is not only a vote for Jasmine, Josephine, and the Connecticut children at risk of child marriage. A vote for this bill is also a vote for America's international obligations and for girls around the world who need your help. UN Sustainable Development Goal 5.3 and other international conventions commit countries, including the United States, to ending the harmful practice of child marriage. Despite those commitments, 21% of the world's young women were married as children within the last 5 years. Another 12 million girls will be married this year alone. In 26 countries, more than a third of girls are married before their 18th birthday. I'm testifying today because before I was lucky enough to move back to Connecticut, I worked on this issue for the State Department in the Secretary's Office of Global Women's Issues. And I know that when my ambassador or even the Secretary of State would call on other countries to ban child marriage, other countries would routinely say, it's legal in America, and we would have nothing to say back. Connecticut should ban child marriage here, not only to protect our own children, but also so our diplomats can better promote the rights and empowerment of girls around the world. America's ability to stand up for girls everywhere depends on our standing up for girls here at home. Other states are taking steps to achieve the UN Sustainable Development Goals and end child marriage. Again, since Connecticut last considered this issue in 2017, all 3 of our neighbors, as well as New Jersey, Pennsylvania, Delaware, and Minnesota, have ended child marriage without any exceptions that could be abused in other countries. I hope you will join those states, and I appreciate the opportunity to testify today alongside the brave survivors and advocates you will hear from later. Thank you very much.
Thank you, Mr. Dodd. Comments or questions from members of the committee? Representative Fishbein.
Thank you, Mr. Chairman. Good morning, sir.
Good morning.
At what age is a human being a child?
Through
Are
age
they
18.
last a child? 18?
Their 18th birthday, according to Connecticut statutes and international norms.
Okay. So we hear in this building that the developmental brain of a child is not matured until they're 25. So why is 18 the magic number?
You know, I'm not myself the expert on child developmental psychology, but what I can tell you is 18 has been fixed in the UN Sustainable Development Goals, in the Convention for the Elimination of Discrimination Against Women, and other international standards as the appropriate age for someone to meaningfully consent to marriage.
I mean, I can tell you in my experience, I've been around a while. There's some 25s that aren't adults, right? So I'm just trying to figure out what is the real difference between 17 and 18 here? And why isn't it 19? If there's a big difference between 17 and 18, maybe there's a big difference between 18 and 19. I mean, we're just pegging an age. So I'm trying to figure out, and I got your answer. I know, I don't think anybody should be forced to do anything, right? Although we do make kids, eat their dinner and their string beans and that kind of stuff. But union between two individuals should be a consensual act. But we do have 19-year-olds who it's alleged are coerced into arranged marriages. That's an act that we should be against as well. So I'm trying to work that all in together. And of the cases that the names that you listed, which is the worst case?
I'm not familiar enough with the details to say which is the worst case. And in part, that's because it is actually difficult to access the required findings of the probate court judges approving these marriages. I would say the worst is most likely just on the paper records that we have through vital records, the case of the woman who was married to someone 11 years her senior, 12 years her senior. But without knowing any of the underlying particulars.
And
I can't
other
really
than
pass on
age,
that.
other than age, you have no information as to why that's violative of some sort of public policy or anything.
No, and not for want of trying to access the probate court records on this.
So you come here with a list of people denigrating the act that was approved. And I'm just trying to figure out why we as government should be changing the law to shame that act without fact. How do I get there? How do I make that connection? Other than the age of the two individuals, arbitrarily 18, how do I link that together?
Yeah, and I should clarify, I don't think this is about shaming the women who have chosen or perhaps been forced to undergo this process. It is about articulating international and national policy here in Connecticut.
Would you agree that there is a procedure? We put the probate court, the judge, they're elected as the gatekeeper to this as of 2017. And there are standards and, they're supposed to follow. So have any of those cases been appealed?
Not to my knowledge. Again, it's quite difficult to access those cases and know whether or not they should have been appealed. I think it is quite difficult to pass on whether these children have enough agency in the system to know that they could appeal those cases. I mean, their parents are the petitioners, but they are in theory, in agreement with the wishes of their parents on this matter and represent it to the probate court judge. I can say we don't track divorces at state vital records, but would appear from public court records, like many of these marriages end in divorce a couple years later. But I would, other people will be here to speak to the particular circumstances in Connecticut. The perspective that I want to contribute to your discussion is that what we do here matters not just to our own children, but to the children around the world. And even if we think that Connecticut's probate court judges are making the right decision in these instances, I can tell you that in less developed and independent judicial systems around the world, those judges cannot be trusted to decide things in the best interests of the child. And if the United States has an exception in instances where there's been judicial review, we have to acquiesce when those countries say, but we have a judge look at these matters. And that is doing real harm to millions of girls around the world every year.
Yeah, I understand bad things happen around the world, but we're here. And if they were appealed, you would have access to that because they go to the Superior Court, everything's on the judicial website. None of this stuff is sealed. So you would be able to get that information. Okay, well, I thank you, and thank you, Mr. Chairman.
Thank you, Representative Fishbein. Comment or question from members of the committee? Comment or question? Seeing none, thank you very much for joining us. Next, we will hear from Brooke Foley. Is Brooke Foley on? Brooke Foley. All right, after. Oh, I thought it was. Oh, she is in person. Okay. You may testify.
Thank you. Good morning. My name is Brooke Foley. Good morning, Senator Winfield, Representative Sastrom, Senator Kissel, Representative Fishbein. I'm the General Counsel of the Insurance Association of Connecticut. The IAC represents Connecticut's property and casualty industry, insurance industry, as well as Connecticut's life insurance and financial securities industries. I'm here to testify today in strong support of Senate Bill 954, an act concerning the reduction of economic damages in a personal injury or wrongful death action for collateral source payments made on behalf of a claimant. The IAC is in strong support of SB 954. This bill would amend section 52-225A to reflect the legislature's original intent of fairly compensating a person who is injured due to someone else's wrongful acts, while also preventing a double recovery and windfall to plaintiffs. I have also submitted written testimony. I would ask that you please read that as well. Medical services are billed at a much higher rate than what the customer actually pays. Rates are usually negotiated, and the result is a final cost of medical services that is usually a much lower amount. That is what is billed. Nevertheless, under the current language of the statute, as was interpreted by the Connecticut Supreme Court in the 2016 Marciano decision, in civil actions for personal injury or wrongful death, when there's a collateral source payment with any right of subrogation, trial courts are not able to consider these negotiated amounts when determining a plaintiff's economic loss for the purposes of determining economic damages. This means the plaintiff receives an entire amount originally billed by their medical provider, not what was actually paid for the medical service. The court's reading of that statute doesn't allow any reduction for amounts that may have been written off by medical providers so that no one actually had to pay. The result has been that plaintiffs collect hugely inflated awards for large amounts of money to reimburse them for bills that were never an actual economic loss to anyone. This, of course, has resulted in higher insurance premiums for everyone. I would kindly ask you to read the law review article that I cite to in my written testimony for a detailed explanation of the impact of this issue. And Senate Bill 954 would correct the statute to reflect the legislator's original intent, and the IAC urges the committee to support this bill. Thank you.
Thank you. Questions or comments from the committee? Representative Blumenthal.
Thank you, Mr. Chair, and thank you for your testimony today. I had a couple questions for you. First of all, could you describe for us what the basis of the Marciano decision was?
So the basis of the court's decision was they literally a literal reading of the language of the statute in that case, which said that you could not do a collateral source. You couldn't consider a collateral source for which there was any right of subrogation. And the Supreme Court was constrained in that case to read that language under the plain language rule, because that's what it said. And there was no ambiguity at all in the language for the court to say, this is what the legislator intended. And even if you read the Marciano case, the court says this is for the legislature to clarify. It's not for the court to read into. And so if you look at the law review article from Western New England College that I referred to in my written testimony, it goes into all of the details of why that is problematic and why it results in phantom damages of very large amounts of money that no one actually has to pay up front. And it doesn't allow the court to then consider, no one paid this money. No one was economically, injured by having to pay out all this money. And so what happens is the court can't consider that and reduce the amount of money that they pay out to the plaintiff, so that the defendant's insurance companies have to then pay out on those awards, the damages awards, and it results in huge damage awards that no one actually ever was at a loss for. And
Well,
of course, the insurance rates go up because of that. Everyone's insurance rates.
I
are
appreciate that
increased.
answer because we've often heard on this committee that the Marciano decision was some sort of loophole that was opened in the law or some sort of unintended decision or misinterpretation. And I appreciate you pointing out to us that the court did utilize the plain language rule and find that the statute was unambiguous. You know, as I'm sure you know, tort reform was not precisely the word, but heavily litigated in this building by our predecessors. Is it your organization's position that that entire endeavor should be reopened completely, or just that this specific item should be renegotiated?
I know that the insurer's position is that this case, the language of this case harms not only insurers, but it harms everyone because the rates are exorbitant because of cases like this, where phantom damages are paid out when there's no economic loss. So I can't comment on whether or not the insurance industry wants to do complete tort reform. I'm just here to testify about this one issue.
Okay, I appreciate that. Would you agree that the bills that medical providers do provide to their patients or insurers after the care they've provided, are those bills legitimate? They're not like falsely inflating them or anything like that?
I think the process, and again, I do not represent health insurers. I only represent
But it's not your
property and
position that
casualty.
they're being falsely inflated or fraudulently inflated in any way?
No, I just think that due to a lot of negotiations, whether it be with insurers or the providers, however the negotiations work, sometimes the bills are much larger than what is actually ended up, you know, after the fact, what they have to pay out. And so what the bill is initially billed at could be, you know, thousands of dollars higher than what eventually has to be paid out on the bill. And so then you have this amount that never was paid that the defendant's insurer has to pay. And they can't reduce the award based on the language of this statute right now as interpreted by this Connecticut Supreme Court and Marciano. They can't consider that. And so that's what we're asking to be fixed.
I appreciate that. But it is true that if the patient does not have insurance, they're on the hook for the full bill, correct?
I would assume so, yes.
If they do have insurance, they're the one who went out and got the insurance and paid the premiums, and their insurer is the one who negotiated down the bills, correct?
Typically, I think so, yes.
Okay. So, and if this is coming into play, we're looking at a situation where a verdict has been handed down by a jury, essentially finding a defendant at fault.
Or a
Correct.
settlement, yes.
Okay, and especially in the case of a verdict where the defendant has been found at fault for the injuries, why is it fair that why would it be fair for the defendant, the wrongdoer in the situation, to be getting the benefit of the negotiation that the patient's insurer did?
The defendant doesn't get the benefit. Nobody is getting a benefit in this case. So what happens is a plaintiff is being compensated for their economic loss. And this case only deals with economic loss. It doesn't deal with pain and suffering or other kind of loss. We're just talking about the economic loss, which is the financial impact that a plaintiff has to, you know, loses if they have to take time off from work or if they pay for medical bills or whatever. We're talking about the amount of money that, say, a health insurance company pays on behalf of the plaintiff when they're injured initially, before they come to court and sue the tortfeasor that injures them. So the defendant doesn't benefit from this.
Well, I mean, if the plaintiff didn't have insurance and had to pay the full cost and wasn't able to negotiate it down, then the bills would have been paid and the defendant would have to pay them, correct? So if the patient's insurer doesn't negotiate them down, isn't it fair for the patient's insurer, or at least the patient themselves, to get the benefit of that negotiation?
Well, what happens is if you read the whole statute, the whole section of the statute is after there's a verdict, the judge can then consider the receipts and the amount of money that's actually paid out on behalf of the claimant as a collateral source payment for the medical bills and whatnot. So if there are amounts that can be considered, the trial court judge is allowed to consider that. So if they pay for their, if a plaintiff pays for their own medical bills, that's considered a loss, an economic loss that they have to pay. So yes, they would be compensated for that, I think, within the judgment. But that's not what we're talking about here. We're talking about when there's another party that makes a payment on behalf of the plaintiff, like an insurance company that pays for the medical bills. And then, so that happens initially. And then after the fact, the plaintiff decides, okay, I'm going to sue this guy that, you know, ran over, hit me in the crosswalk or whatever it is. And then the jury gives a judgment on their behalf, or there's a settlement, you know, on their behalf. Okay, this is the amount of money that we're going to award the plaintiff for their economic damages and their pain and suffering. And after that's all done, then the court can consider who else made payments on behalf of the plaintiff for the medical bills. That's the issue that we're talking about here.
No, I understand. But I think it's important to consider it in the context of the fuller payment system. And, you know, I think maybe you might agree that there might be flaws in how we pay for medical bills or how we insure on the health insurance side. And, or maybe you don't have any opinion on that very affirmatively.
My
But
opinion is that it's very complicated. I don't represent the health insurance industry. I'm sure there's health insurance people that might comment on this bill as well.
yeah, but I mean, to me, it's important to note that, you know, in this sort of situation, that negotiation has happened up front. And, you know, there's necessarily an efficiency in the system because of the way the system is organized. And lots of people have lots of opinions about how it should be organized or perhaps reorganized. But, you know, to me, it makes a lot more sense to provide whatever perhaps inefficiency benefit there is to the plaintiff or the plaintiff's insurer rather than the defendant or the defendant's insurer, especially because I think otherwise it might provide less incentive for individuals to get insurance themselves. But one more question. When a judge does consider whether these medical bills should be awarded, they do have to make, there has to be a determination that they were reasonable, correct, under the current law?
Yes, and I think that the point of paying the plaintiff is to compensate them for their economic loss, their actual economic loss, and not for phantom damages that were not a loss that they incurred.
And if the judge decides that the bills were unreasonable, regardless of whether they were paid, the judge can reduce them in the judgment, correct?
I am not familiar with exactly what the trial court does at that point.
Okay. Well, I appreciate your testimony with us today. And thank you, Mr. Chair.
Thank you. Comment or question from other members of the committee? Comment or question? Seeing none. Thank you for joining us this morning.
Thank you so much.
Next, we will hear from Frady Reese. Good morning, and you may testify once you're seated.
Thank you. I'm here in strong support of HB 5659. I am here as a survivor of a forced marriage and as an advocate. I founded Unchained at Last to help survivors in Connecticut and across the US to escape forced marriages and child marriages, and an expert. My research and writing on this issue has been published extensively. I want to talk about, I want to answer some of the questions Representative Fishbein brought up, specifically about emancipation. And you talked about whether an emancipated minor would be allowed to marry if this bill passed. And the answer, my understanding, is no, and that is really important, and here's why. And currently, also this question came up before, whether currently an emancipated minor can marry without the parental consent with air quotes and judicial approval that are in place for other 16 and 17-year-olds who marry right now in Connecticut. And the answer is no, they can marry right now without that. But here's why it's so important to end child marriage, including for emancipated minors. So first of all, let's think about why emancipation was created. It was created to help teens who for some reason cannot be reunited with their parents. And it gives them some limited rights of adulthood so that they can navigate the world independently until they turn 18 and get the full rights of adulthood. Nobody needs marriage before the age of 18 to navigate the world independently. It is not necessary. But beyond that, if we kept that loophole in the law and eliminated the rest, that is extremely dangerous, because what it does is it opens up an avenue for parents to force their teen to emancipate in order to force them to marry. And if you're going to ask, well, how could you possibly force a teen to emancipate? Under Connecticut law, a parent or a guardian can submit the petition for a teen's emancipation. It doesn't have to come from the teen. And a judge can grant it if it's in the best interest of the parent or the guardian. It doesn't even need to be in the best interest of the minor. So we are very concerned that if we eliminate the other loopholes and leave that, the parents can force their children to emancipate in order to force them to marry. And Judge Fishbein, I'm sorry, Representative Fishbein, you talked before about the judicial review process, which you described as a high burden. I just want to, as an advocate working with teens who are forced to marry, I just want to talk about how that actually plays out in real life. Unfortunately, every single survivor we have worked with who went in front of a judge as part of their process of being forced to marry lied to the judge about what was happening. They were too scared about what their parents would do to them when they got back home. We have, in many cases, their parents gave them explicit instructions about what they were going to do when they got to the courthouse. We have never once in Connecticut and across the US found a teen who was brave enough to tell the judge that they were being forced to marry. Unfortunately, the current situation, the current process does not protect minors. In a forced marriage situation, the perpetrators are almost always the parents. When a teen is being forced to marry, it's probably their own parents doing it to them. And it's unfair to ask that terrified teen to go into a courthouse and find some way to tell a judge what is actually happening. You also asked before about why 18? What's the magic difference, 18 and 17? And I wonder if I'm answering the question, if I can go over the 3 minutes, Chair?
Very briefly.
Okay, very briefly. And then if some of the other questions that came up, I'm happy to answer as well. We're not arguing that you wake up on your 18th birthday with a newfound wisdom and maturity and the sudden ability to choose a life partner. That's ridiculous. But you do wake up on your 18th birthday magically with the rights of adulthood, and those rights, and you'll hear soon from some of my colleagues also testifying today, why the rights of adulthood are so crucial to safely navigate a contract as serious as marriage. If you don't have the right to leave home, to get into a domestic violence shelter, to retain an attorney, to bring a legal action in your own name, you're a sitting duck. You can too easily be forced to marry. And even if you are brave enough to reach out to advocates like us at Unchained to ask for help, there's almost nothing we at Unchained can do for you until the day you turn 18. We're almost always able to help the adults, but it's rare that we have a positive outcome with a child.
Thank you. And just for clarification, because when you sat down, you misstated the bill number. I believe it's 6569, just for
Yes,
the record.
6569, what did I say?
5659, I believe. Comments or questions from members of the committee? Comments or questions from members of the committee? Representative Gilchrist.
Thank you, Mr. Chair, and thank you so much for being here today and for your advocacy. You're just a wealth of knowledge on this topic, and I really appreciate you bringing this issue to our state and leading the way across the country. Thank you.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you very much for your work and for joining us this morning.
And I wonder if some of the other representatives want to ask me the questions that came up about pregnancy and military.
Very much.
No.
It happens. But next we'll hear from Stephen Wisnick-Karp.
Thank you. My name is Stephen Wisnick-Karp.
Morning.
Morning. I'm Executive Director for National Association of Social Workers, Connecticut chapter, and we're here today in support of Raise Bill 6569, an act concerning the minimum age to be eligible to marry. Current marriage law has already been reported. It has some loopholes, which allows 16 and 17-year-olds to marry with the consent of one parent in the probate court. It also allows a loophole for those who are emancipated before age 18. Ending child marriage is a national movement. There are 7 states that have passed legislation to end marriage before 18 with no exceptions. Crucially, this includes each one of the neighboring states of Connecticut, Massachusetts, New York, and Rhode Island. Additionally, nearby states, New Jersey, Pennsylvania, and Delaware have ended child marriage, as has Minnesota. Vermont and Maine are actually considering legislation this year to end child marriage. We do not want to be the last state in New England to allow child marriage. Connecticut does not have a residency requirement for marriage. And if it continues to allow parents and judges to enter minors into marriage, we will become a distinction of the state where marriage is a go-to state. We don't really want to be a destination for child marriage. We may want to be a destination for a lot of things, but not for that. by setting no exception legislation and only allowing those 18 years old to marry in Connecticut will end this state shopping that would target our state. Ending child marriage is also a global movement. 193 countries, including the USA, agreed to United States Sustainable Development Goals. Goal 5 is to achieve gender equality and empower all women and girls. Under that, target 5.3 is to eliminate all harmful practices such as child, early, and forced marriage by the year 2030. We don't have to wait to 2030. We can end child marriage effective July 1, 2023. Child rape is punishable by law, but not if the rapist victim is their spouse. Child marriage is the means of child trafficking under the guise of marriage. And that this bill will end that too. A child trapped in a marriage without individual rights will come to an end with this legislation. As social workers, we see the harm that child marriage can cause. Such marriages are often detrimental to child's mental health and can have long-term negative effects. As a state, we have responsibilities to protect children from known harms, and child marriage is such a harm. We urge all the committee members to vote in favor of Bill 6569. Thank you.
Thank you. Comment or question from members of the committee? Comment or question? Seeing none, thank you very much to join us to testify this morning. Next, we have Olivia Rinkus. Is Ms. Rinkus here? Kathy Flaherty.
Hi, I'm sorry. I'm actually here.
Oh, there you are.
Thank you. Sorry. Good morning, and thank you to the Judiciary Committee for the opportunity to testify. My name is Olivia Rinkus from the town of North Stonington. I'm also a student at the University of Connecticut. I'm here today to testify against SB 924, an act providing immunity from civil liability to a physician who accompanies and assists a state, regional, or municipal SWAT team. And if an action taken by a police or SWAT team, whether municipal, regional, or state, leads to the death or injury of an individual, then all the individuals involved in this action need to be held accountable. Accountability is integral to keeping law enforcement agencies and other state agencies transparent to the public, and it ensures that individuals who are harmed or killed in a law enforcement action receive proper care for the traumas they've experienced. I'd also like to testify in support of HB 6569, an act concerning the minimum age to be eligible to marry. I am strongly in support of all actions taken to protect children in Connecticut from harmful or manipulative coercion and abuse. Thank you again for the opportunity to testify.
Thank you, Ms. Rinkus. Comment or question from members of the committee? Comment or question? Seeing none, thank you for joining us again. I'm sure we will see you again in the future. Kathy Flaherty. Good morning. You may testify.
Good morning, Senator Winfield and all the members of the Judiciary Committee. My name is Kathy Flaherty. I'm the Executive Director of Connecticut Legal Rights Project. We are a statewide nonprofit that provides legal services to people who receive services from DEMIS. I'm here to testify in support of HB 6739 that would create a state cause of action for HIPAA violations. The only suggestion I would have is that if a state agency is a covered entity that violates the law, that they're explicitly included in the law and that it's either indicated to be explicitly a waiver of sovereign immunity or that they're covered entities. And that's all I had.
Okay. Comment or question from members of the committee? Comment or question? If not, thank you for the suggestion. I am sure we will see you again.
Thank you.
Brian Anderson.
The Judiciary Committee. I'm Brian Anderson. I'm a legislative director for council for AFSCME, a union of 30,000 public and private employees in Connecticut. We oppose House Bill 6570, which would take away qualified immunity for municipal employees regarding motor vehicle negligence. About half of our members are municipal employees. This bill appears to take away the qualified immunity in motor vehicle negligence cases that our members are currently protected by. Our members have to drive and operate equipment in some pretty daunting circumstances. Our public works members drive snowplow, salting, and sanding trucks. They drive in the midst of blizzards. They drive when black ice is on the road. They drive during hurricanes and other emergencies. They're often ordered into double shifts or even worse. State law allows an exemption for them to drive beyond legal hours for other types of heavy truck operators. They often have to drive exhausted. This is not by choice, but by necessity of protecting the public and keeping the roads open for emergency vehicles, for commerce, and safe passage of the public. Our police officer members have to drive in hazardous conditions. Often officers must exceed posted speed limits in order to do their duty. Due to the shortage of officers, these members are also often ordered in to do double shifts or more so. Our school bus drivers must drive in bad weather and challenging conditions also. Our members are not wealthy people. They tend to receive low to middle incomes. They tend to live modestly. They do not have the broader economic shoulders that their employers have. This bill threatens these employees with exposure to negligence motor vehicle suits that they are currently shielded from. Their qualified immunity is just that, qualified. They'll be penalized if they drive in an irresponsible manner. They can be disciplined, lose their jobs, or lose their licenses. If they commit a willful or malicious act, they can currently lose their qualified immunity. And of course, they're all subject to criminal prosecution if they break the law. We urge you not to diminish the motor vehicle immunity that that our members currently are able to access. Thank you for your consideration. I'd be happy to answer any questions.
Thank you, Mr. Anderson. Just a question for you. My understanding of the bill is that this bill is dealing with the immunity of the political subdivision, not the individual. Do you understand it differently?
No, but my understanding is that if the town is sued and these folks don't have that immunity, that damages could be asked for from our members.
I have a different understanding, but I'll let others
Okay.
ask their questions first. Senator Kissel.
Thank you very much, Chairman Winfield. Thank you very much, Chairman Winfield. And Brian, it's always good to see you. You know, historically, I haven't been opposed to your advocacy or a lot of the things that you champion here in the Legislative Office Building and over at the Capitol. It's my understanding, and I think this is essentially the issue that got voted out. I think it was close to unanimous in both chambers last year, and then ultimately vetoed by Governor Lamont, and I'm not sure why, but he did have a veto address, but I disagreed with his rationale. So here it is before us again, and my understanding is that this exposure to potential liability is already part of the construct regarding the state. And this would merely have it mirror, and I agree with Chairman Winfield, that the political entity, the municipality, would be exposed just like the state of Connecticut. And I appreciate everything that you just testified to, that, you know, whether, you know, and I don't know, we're supposed to get a lot of snow tonight, who knows? And certainly your membership that are on the municipal level have daunting things that they have to undertake. Nonetheless, that the totality of the circumstances in an action for negligence would be assessed. So it's not just, was there an accident, but if there was an accident in the midst of a huge hurricane or a blizzard or, you know, or a high-speed chase, it's was there negligence under that facts and circumstances, not just that, oh, there was an accident, therefore there had to be negligence. There would have to be an assessment by a fact finder, either a judge or a jury. And so I just sort of look at it as very simple. What's good for the goose is good for the gander. What's good for the state is good for the towns. And the towns may not like it because they may think their rates may go up, and that's between them and their, you know, are they self-insured, partially, who knows? But I don't think, and let's take the potential exposure of the individuals off the table, because I do think that is, and if that's what it meant, I would not be supportive of it. But given the way it's been characterized to me last year and this year, do you still have that objection if that's not part of the equation?
The strongest concern we have is the well-being, economic well-being of our members. If that issue is mitigated, then our objection is pretty much taken care of.
Thank you so much. And that's all I needed to hear. Thank you very much, Mr. Chair.
Comment or question from other members of the committee? Comment or question? Seeing none, Mr. Anderson, we talk a lot. We will make sure that we are all clear before this bill advances. And thank you very much for joining us.
Thanks, Mr. Chairman. Thanks, Senator Kissel.
Loretta J. Is Loretta J with us?
Good morning, Chair Whitfield, Chair Stafford, Senator Kissel, and Representative Fishbein. Oh, left me. And distinguished members of this judicial committee. My name is Loretta J. I'm the managing member of the Justice of the Peace Association. In this capacity, I represent civil marriage officiants in Connecticut and throughout the Northeast. And I urge you to support HB 6569, which increases the minimum age to marry it to 18. For officiants, kids getting married is personal. When a 16 or 17-year-old gets married, they are 3 times more likely to be beaten by their spouse compared to a 21-year-old. They're at significantly higher risk of suffering from psychiatric disorders. Girls, and it's usually girls, who marry are 50% less likely to finish high school and 4 times less likely to graduate from college. They are 31% more likely to live in poverty. In fact, marriage before 18 is recognized as a human rights abuse by the U.S. State Department because it produces devastating lifelong consequences. In response to Representative Osborne's question, pregnancy is not an excuse either. Pregnant teens who marry are more likely to suffer economic deprivation and instability compared to those who stay single. And because 70 to 80% of child marriages end in divorce, there's an even greater likelihood she'll have less education and less income, with potentially nowhere to go, completely on her own when her marriage fails. When people think about a marriage ceremony, they usually think of either a religious or a secular wedding celebration. But actually, all that is needed is for the officiant to witness the couple affirming their intention to be married and then processing the paperwork. No frills and no fluff required. We must remember this is a legal act. Now, I started my career at DCF, charged with protecting children from abuse and neglect. So it shocks me that our current law has a built-in loophole that allows parents to enter their teen into the legal contract of a marriage, even though we know that parents are the ones who are the most likely to coerce their kids into this arrangement, and that once married, kids do not qualify for legal protection, neither through DCF nor other adult services. Members of the Justice of the Peace Association are professionals who take their responsibility very seriously. They abide by a code of ethics that dictates acting in their client's best interest. When we polled our members in 2018, 95% responded that they would likely refuse to marry a minor and wanted 18 to be the minimum age, no matter what. The current law puts marriage officiants in a legal and ethical quandary. Officiants are on the front line, feeling complicit if compelled to subject such a child to such a bleak future. Therefore, I respectfully ask you to vote in favor of HB 6569 and make 18 the legal age to marry in Connecticut without exception. And I thank you for this opportunity to share these comments with you, and I welcome your questions or discussion.
Thank you very much. Senator Kissel.
Thank you very much, Chairman Winfield. Appreciate your testimony and your work when you were with DCF and currently. This is probably not politically correct, but I just have to ask it. Does this practice tend to be more prevalent with certain recent immigrants or national groups, or, and I'm not trying to characterize any nationality or ethnicity negatively, but it just seems like perhaps this may occur in certain parts of the state more often than others, simply because more recent immigrants may be gathered there. I just don't have the level of expertise that obviously you have. And just to get a better idea of where this may be happening and why is this being pursued? because it strikes me that the story is always sort of about parents, strong holding their daughters to try to get married to someone else. And maybe it's a put together marriage. And I just don't, my life hasn't bumped into this, nor have I heard about this up in my neck of the woods. Not that it doesn't occur, but I'm just expressing my innocence on this subject.
So thank you for the question, Senator Kissel. This affects all ethnicities, all races, all socioeconomic standards. I can share with you that I've been told that the Commissioner of Department of Children and Families is in support of this bill, and that to that question about imagining why this may happen, I can also share that there are times when a parent may bring forward, the parent can initiate it, and it only takes one parent of a child to initiate this action. So one parent can be opposed, but the other parent can bring forward the matter to the court as a way of getting out of paying child support or for any other reasons. It can be because they don't approve of a pregnant teen, but that doesn't mean that the teen is wanting to marry that child. It could also be to avoid a criminal action in terms of the partner, if the other person is an adult, and there could be a statutory rape charge there, a difference of age. There's lots of different reasons that could be coming forward, and it affects all different groups of people. There's not one category.
Yeah. Well, I appreciate that answer, but no, that's a whole series of kind of crazy scenarios that probably could occur.
There's
The
so many.
longer I live, the more I'm less surprised by things that I learn. So, good and bad. I don't want it to all. I'm a glass half full kind of guy, but I appreciate that, and I appreciate your testimony. Thank you, Mr. Chair.
Thank you.
Thank you, Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon. I don't even know. Is it morning or after? It's probably,
I
it's got to be close. Anyway, it's probably still morning. You mentioned a poll that the Justice of Peace had represented 95% of them, I believe is what you said, that they would not marry a 16 or 17-year-old. That's fair.
That is a poll we polled our marriage officiants to get their position on this matter before taking on the advocacy issue.
And what was the actual question?
Sir, I have in my written testimony, there are references, and there's a link to the actual survey and the question.
Do you recall what the question was?
I'm sorry that I don't.
Okay.
But it was, would you feel comfortable performing, or actually, no, the question was, would you like to make 18 the minimum age to marry, no exceptions? I actually do recall. And that's, my exact language may be off, but the question was, do you want to raise the age to marry? And then there was a section for comments, and the comments were, many said they would likely not perform such a ceremony.
Okay, so it's fair to say that the individuals that were polled were not informed as to the process. That in order for a 16 or 17-year-old to get married, it isn't just, I want to get married, go get a license, which would be my impression from the question. They have to apply to the probate court, a judge has to make an order, so on and so forth.
It was not a blanket poll. It was embedded in our website, where we provided lots of information in terms of the law, what is required. And it was not a cold call. There was discussion and informative member support articles about the law, about the 2017 law, and what the 2017 law means, and then what raising the age to 18 without exception would mean. And then we polled to get our membership's position on this. And this was prior to joining the National Coalition to End Child Marriage, as well as an organization.
Okay, and then do you have any knowledge as to, Mr. Doc appeared this morning with a document that represents that 31 individuals had been married post October 1, 2017 under the new situation, the new requirements. Do you have any knowledge of any of those cases that we should be utilizing in our contemplation of changing this?
That information was not, we're not able to get additional information about them. But I can share a story about prior to the 2017 law, about a 13-year-old child who was married to an adult, and that went through probate court, and the probate court judge approved such a marriage.
Yeah. and
So that's,
for that reason, I supported the bill in 2017, right? So
Yes.
I'm moving forward. So
I bring that forward, but the reason I share that as an example, though, sir, is as the judge referenced earlier, that we have probate court judges who hear this, but actually it was, as Ms. Race described earlier, that the children will oftentimes say whatever their parents want them to say. So even though we have the courts there to hear the story, it cannot always be relied upon. It's based on what is in the parent's best interest, not what's in the child's best interest.
well, I understand that's the anecdotal position, but I still have not been, none of these cases have been appealed. These are still minors. So if there's abuse in the situation, certainly DCF could get involved.
No, sir.
Well, why not?
That's an interesting question. Thank you for, so I wondered, I worked at DCF for 12 years and I never heard about child marriage. I didn't learn about it until the 2017 law. And that's because once a child is married, they no longer qualify for services from DCF. They do not qualify, they can't access
Let's talk
adult
about-
services, and they cannot qualify or be protected from child services either.
So once they are married and they are abused, well, let's just say that a married woman, 17 years old, goes to their doctor and complains that they are being sexually assaulted by their now spouse on some frequency. The doctor is a mandated reporter under our statutes. So you're telling me that the doctor picks up the phone, calls DCF, and DCF's response under the statute is we can't do anything?
That is my understanding, sir.
What's-
That because they are not in the care of their parent or a guardian, they are now married, that DCF will not intervene.
And what is that understanding based upon?
Based upon my discussions with DCF, my discussions with my understanding of what DCF's protocols are.
Okay, well, maybe that's something we need to deal with. But anyway, I mean, looking at the numbers here, if I am to take Mr. Doc's document as being truthful, it's 31 individuals over a 5-year period, which is on average 6 people a year. I mean, one of them could be a bad one, right? One of them,
Just
I mean,
takes one.
and we have adults that get married that, you know, I do a lot of domestic violence cases. We certainly have domestic violence with adults and that kind of stuff. So I'm just trying to wrap my arms around what the crisis is here.
Sir?
Yep.
I earlier you had said, is there a crisis? In my opinion, one child subjected to this future is a crisis. And we need to protect, as someone who, in addition to wearing the Justice of the Peace Association hat, I also wear a hat where my work is spent to support children and families through people with disabilities and behavioral health or other types of disability. And I spend my days, because if one child is out there being hurt, then we need to do something about it. So I urge you to share that sentiment.
Well, I'm looking at what the law is presently, and we are requiring our probate judges to make affirmative findings that the minor consents to the marriage, and such consent is based upon an understanding of the nature and consequences of the marriage, that the minor has sufficient capacity to make such a decision. The minor's decision to marry is made voluntary and free from coercion. The marriage would not be detrimental to the minor. It's a very high standard. And I'm trying to wrestle with. Nobody has presented us with, well, me at least, with any particular case post October 1, 2017, in which a judge screwed this up. And that's what I'm wrestling with. So
It's
I-
confidential. See, that's, and part of it is, you know, how do you expose something when it is someone's private business and it's confidential? But we do know that the law allows the parent to bring it forward, not the child. And as Ms. Reese had said earlier, they've never experienced a single child who has said that they have said the truth to that judge, that they have all lied because that's what their parents expected them to do. Because the alternative, if they did not lie, was to go back home to those same parents who are forcing them to come forward. It's a pretty rotten circular situation, isn't it?
However, I have had cases where similar tests have been in probate court. And usually the judge will ask people to leave the room, question the individual and trying to ascertain that. I still have not heard of, well, I'll stop repeating myself. So thank you and thank you, Mr. Chairman.
Thank you very much, sir.
Thank you. Wait. Representative Osborne.
Thank you, Chairman Renfield. So I also come from a child protection background. And I'm also sensitive to the balance of religious freedom in this particular case. So, you know, we have to hold both of those things when we're considering this law. And of the cases you're talking about, where the children have later said that they didn't really want to consent, they felt they had to consent. Are any of the people you're talking about, the 31 people who have been approved by the probate court since 2017 to marry under the age of 18?
I'm sorry, I missed the question.
So we've had 31 people married under the current law since it went into effect in October 2017.
Yes.
You said that people that your organization or other organizations you're familiar with have interviewed women married under this law who have said unequivocally they didn't want to say yes, but they did. They lied to the judge.
Yes.
Are any of those people that you're talking about, the 31 people who've been married in Connecticut since October 2017?
Not to my knowledge.
So are any of the statistics that you cited to us about the outcomes of child marriage, are any of them concerning the 31 people who were married in the state of Connecticut since this law went into effect?
As I shared with Representative Fishbein, those, I have the list of those names, but that's all that we have. I do not have any particular information regarding their personal situations.
Okay, I think you had said it was confidential, correct?
Well, it's someone, I don't know if it's confidential, it's someone's private life. I don't know, you know, the names are available and the ages of each party, but what their stories are, I'm not familiar with them.
Well, you would know if they'd filed for divorce, you'd know if they'd filed for a protective order, you would know if there were criminal action concerning them, correct?
If I were to research each individual person, I may.
Okay, because what I'm concerned about, I am concerned about child protection, and I am concerned about children being forced to marry when they don't want to. Absolutely. But I also really want to understand if the law in its present form has prevented that in the state of Connecticut. So I'm not hearing that, at least you, maybe there's other data that's coming before us today. I'm not hearing that we have any good data that the existing law is failing our youth, our 16 and 17-year-olds. I don't have any data about that before me today. Do you have that information? I'm not trying to be argumentative. I'm really trying to balance these competing issues, right?
Thank you, Representative. I am familiar with the story that happened in October of 2021, but I don't have permission to share details. But I have heard a story that that the marriage did not go through, because it was recognized by somebody and they were able to intervene.
So isn't that an example of the law working, that there was an applied for marriage that didn't happen? Isn't that the law working?
Well, it's the law working, but I don't know that it was the law that is this law, in fact, that was able to work. It was something else. So
do you have examples of, and forgive me, do you know of, so we've had 31 approved marriages in that time. Do you know how many marriage applications have been denied by probate court? Is this, are our judges just rubber stamping these applications, or is there a real critical consideration of the statutory factors that Representative Fishbein gave us before? Are judges really making these hard decisions, and are they rejecting some of these applications?
perhaps that's a question we can ask the judge. I do not have that information.
Okay, thank you very much. And I don't mean to put you on the hot seat. I'm really grappling and trying to understand this and trying to make sure we get it right.
So thank you. And if I may just respond to that, I appreciate that. And it comes down to the law. And I think it comes down to that our kids, our 16 and 17-year-olds, don't have the legal rights that they need to live and be married. And to, I'm not sure what religious need there is to compel someone that they have to get married before they turn 18 years of age.
But that's the crux of religious freedom. You don't have to understand somebody else's religion to understand that they hold it truly and dearly to themselves. And there are many, many religions which hold marriage as the most sacred of sacraments and the ultimate goal in their religions. So thank you very much for your input. I appreciate that. No,
Thank you. Representative Howard.
Thank you. Good morning, ma'am. Did I hear in your opening testimony that you used to work for DCF?
Yes.
So I just one quick question. You brought something up in Representative Fishbein's example where somebody makes a disclosure to their doctor. If they're married, I think you said that DCF would not take the case by nature of their marriage. I'm curious though, would DCF still send a 737 over to local PD in that
If
case?
it's a sexual assault?
Yeah, well,
Well, if it's
domestic
a sexual
violence.
assault, then I don't know. I don't know if they would take that step or if they would just say that they don't accept the case. I don't know the answer to that.
Okay, that's it. Thank you.
Thank you. Representative Dubitsky.
Thank you, Mr. Chair. Thank you for coming in. Your testimony has been very interesting to me. It sounds to me like you're saying that because 16 and 17-year-olds don't have the rights to be adults, that they should also be denied additional rights to be married. Wouldn't it make more sense to just give them more rights as opposed to take away their rights?
So we're going to change the laws so that a 16-year-old could hire an attorney and could stay at a domestic violence shelter. And so that would change the conversation. But as of today, that's not an option. As of today, a 17-year-old cannot get help in a domestic violence shelter. And they cannot hire an attorney on their own.
Okay, so perhaps that may be something that the legislature could look at, is to give them more rights as opposed to less.
I'm sure that's a different conversation. I think the question before us today is, as of today, they do not have those rights. So perhaps if that happens at that time, then we could look into expanding and including children to be allowed to get married once we've already changed those other laws. But as of today, those laws are not in place. So therefore, I believe that they should not be allowed to get married.
Okay. What's the minimum age to get an abortion in Connecticut?
I don't know.
Do you know what the minimum age to have sex change surgery is?
No, sir, I don't.
Okay. All right. Thank you very much.
Thank you,
Mr.
Representative. Comment or question from other members of the committee? Comment or question? Not, thank you very much for joining us today.
Thank you all very much.
I believe Representative Johnson has a question.
I do. Thank you very much, Chair. I appreciate that on Zoom here. I want to thank you for your testimony, and I think it provides a unique window into this issue because of your work with DCF. I will say that I have heard from some young folks who live in my area that they were almost trafficked. And this is an issue that's very important to them because they see this as a law that could prevent in some part from this happening to others. Could you speak a little bit about, I know you mentioned the justices of the peace, I believe, in your testimony. Are we finding that young people are being put forward by adults in their life in situations where the justices of peace, you believe, are somehow speculating that trafficking may be involved? Do we have that information? I know you need to speak in generalizations.
Yes, sir. Thank you for the question. The Justice of the Peace Association is aware of trafficking situations. We are working with the Secretary of State's office and others in the legislature to address ways of improving qualifications for justices of the peace to help better recognize that our association provides training to recognize trafficking and children. The situation that I mentioned from 2021 was a trafficking situation. So that is another question, and children are certainly affected by that as well.
And is it fair to say that, just as one final question through you, Chair, is it fair to say that you see this legislation as an important tool in our toolkit to address child trafficking in our state?
Absolutely. Absolutely. This eliminates two more, parents are the ones who may be coercing their children to marry and to force them to marry and to traffic.
Thank you. I felt compelled to ask these questions because of the young people who live in my area who are very much in support of this legislation, and we're so for the 2017 legislation as well, and see this as a continuation of a more perfect way to address this very important issue that affects them. I appreciate your testimony.
Thank you very much.
Thank you. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us today.
Thank you.
Next is Kelly Petter. You may begin.
Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the committee. I'm Kelly Petter. I'm a partner with Robertiano, Kelly and Brady, and treasurer of the Connecticut Defense Lawyers Association. I'm testifying in support of Senate Bill 954. The time to act is now. You need look no further than the Florida and Louisiana insurance market crises for evidence that retroactive legislation and bailouts do not work. Common sense, balanced action needs to be taken in real time to prevent the damage. Acting is in the best interest of your constituents. Our system currently allows plaintiffs to collect phantom damages. Those are amounts that have never been paid and will never need to be paid. Let me explain how this works. In cases involving Medicare, Medicaid, and fully self-funded ERISA plans, a plaintiff's base value of their medical bills might be hundreds of thousands of dollars, over $400,000, when the insurance policy actually only paid about $80,000 to satisfy those bills. The system currently allows the plaintiff to keep the difference between the $80,000 and the over $400,000 in medical bills that was never paid and will never be paid. To be clear, this would not prevent a plaintiff from collecting for damages they actually incurred. A plaintiff will still be entitled to collect for pain and suffering, effect on life's activities, and all of the other non-economic damages that they incurred. A plaintiff will also be entitled to collect for amounts that were actually paid out of pocket and needed to be repaid. Why do you care? Because this isn't about one plaintiff. This is about hundreds, if not thousands a year. We heard before that this only impacts verdicts. That's not true. This impacts settlements. This impacts every single case because the Marciano decision is being argued as a basis to increase the amounts that are being paid for amounts that don't have to be paid. And what does that mean? It means it's more costly to insure Connecticut risks. It means your insurance premiums are going up and your constituents' insurance premiums are going up. We're asking you to restore the system to how it operated before the Marciano decision in December of 2016. The Marciano court did not render a decision about the manner in which the system operated before then. The court simply looked at the statute and interpreted the words as written, which they were required to do under the law. But they said in their decision that it is the legislature's job to decide what was intended. And we're asking you to restore the system to how it operated before. One thing that's really important is this doesn't happen when private health insurance is involved. When private health insurance is involved, there is a collateral source reduction. This only happens in some cases.
Thank you. Comment or question from members of the committee, Representative O'Day.
Thank you. Thank you, Mr. Chair. Just to clarify, how did it operate before Marciano?
Before Marciano, there would be a collateral source reduction for the difference in value between a right of subrogation and the total face value of the bills. So in the example I gave before, if the total face value was over $400,000, but the Medicare or the Medicaid or the fully self-funded plan paid about $80,000, then the defendant and its insurance company would still have to pay the $80,000, the economic damages. And then there would be a reduction for that phantom damage amount that was never paid and will never have to be paid.
I heard some testimony earlier that there was some study done as to what this is costing, costing all of us in premiums. Is that something that we're aware of? Like, do you know what you say it costs everyone? What is that cost? If you know.
I'm sorry, I don't personally have that number, but I know that there is a study that's available that is available through the group that testified earlier, and they have that data that they submitted with their testimony.
There were some questions about reducing medical bills that are not reasonable. As a trial lawyer, I haven't seen that happen yet, but I guess my question to you is, have you experienced that happening after a verdict?
I have not experienced that happening. And in fact, what I've seen since the Marciano decision is that when it's been argued that the bill should be reduced as unreasonable, as was suggested previously, for this exact reason, the Marciano decision was actually used as a basis to argue that it cannot be done. My understanding of reasonable in the term of fair, just, and reasonable damages is actually a characterization of the quality and character and the nature of the treatment received by an injured plaintiff. So was the treatment reasonable in light of the damages claimed, and were the injuries actually causally related to the injuries? It's not a question of whether the bill itself is reasonable for the nature of the treatment. One other thing, if I may clarify, the question was whether a judge might reduce the damages based on the reasonableness. And in fact, reasonableness in that context is not a decision for the judge. Fair, just, and reasonable damages goes to a trier of fact, which most often is a question for the jury. And the jury is told not to consider things like health insurance and reduction for health insurance. So in fact, they would be strictly admonished not to consider it in these circumstances.
Thank you very much for your testimony. Thank you, Mr.
Thank you.
Thank you. Comment, question from members of the committee? Comment or question? Seeing none, thank you very much for joining us.
Thank you for your time.
Eric George.
Senator Winfield, Representative Staffstrom, members of the Judiciary Committee, I am Eric George. I'm president of the Insurance Association of Connecticut. And I'm here to talk about the two remote notarization bills that you have before you, Senate Bill 1040 and House Bill 6713. In reference to what's going on with the Secretary of State, I just wanted everyone to know that we are in the process of working with the Secretary of State to attempt to address their concerns and work on language with them. And I just wanted this committee to know of that. These bills would create a system, voluntary, that would allow for remote notarizations and still allow in-person notarizations as well. How did we get here? Well, while this issue has been discussed nationwide for many, many years, COVID-19 and the pandemic really brought it to the forefront. And quite honestly, industries like the insurance industry were uniquely impacted. In the insurance industry context, there are many business-related documents that, because of a rule that was established many years ago, they must be notarized. When folks were told that they could not come into work and had to work remotely, much of those notarizations began to backlog. And even since I would say, as we are moving beyond the COVID-19 pandemic, we still have significantly reduced in-person attendance in many companies, especially in the insurance industry. Sometimes they're operating at about a 30% capacity. So while in order to get through those notarizations, many notaries are on staff, this is still turned into a major issue because the coordination of their schedules with the individuals who will have to have their signatures notarized becomes extremely problematic. And we're talking about from the context of how we deal with it, I would call them mundane documents. We're talking about filings that insurance companies have to make with the National Association of Insurance Commissioners, certain affidavits, certain title documents. The bills before you today do generally the same thing, but they do envision two different scenarios. Senate Bill 1040 is a streamlined approach to deal with business to business, commerce only, if you will, types of documents and transactions. House Bill 6713 is more expansive. It is the broader Rolona model that we've heard speak of today, which is a national model. And it envisions dealing with such complex transactions as real estate transactions. Senate Bill 1040 really looks at sophisticated parties, whereas 6713 not only looks at sophisticated parties, but consumers as well, and deals with where wealth is being transferred. 1040 does not. So 1040 is a much more streamlined approach. We support both bills. Let me be clear.
Mr. George.
And yes, I've probably gone beyond my time. I'm happy to answer any questions. I can explain how we got here if anybody would like to know.
Thank you very much, Senator Kissel, followed by Representative Oakley.
Nice to see you, Eric. It's great as always. Please give my best to your lovely wife, Ann.
Will do.
I share a lot of the concerns that some folks have articulated. I believe Representative Fishbein had raised some questions earlier on. I am very, very protective of the real estate situation in Connecticut. We are the land of steady habits. I watch these ads, like late at night, and it's this insurance that comes on that says, hey, I woke up and all of a sudden I didn't own my house. And I'd like to believe that in Connecticut, that just doesn't happen. I haven't heard of it like starting to spread in Connecticut. I don't want it ever to happen. Those of you here in the building probably are aware of me moaning and groaning years past, not that long ago, but around pre-pandemic, about having my identity stolen. Still, the credit situation has not been recovered. So when the fraudsters act, they can do devastating damage to an individual. So do you have a problem if we go down this path, sort of going much more slowly and more protectively when it comes to real estate documentation and things like the things that the chief probate court administrator spoke of, the wills, the trusts, the things that we wouldn't really uncover their impact until years after they've been executed, and perhaps the person who executed them has passed. I am wary of those moving down this road at super juggernaut speed, but the business to business, I have far less concerns, and I think that we could effectuate all the needs of your association. Where are you on that sort of divide?
Thank you for the question, Senator Kissel. So perhaps let me give a little bit of a history as to how we got here. 42 or 45 states have some system of remote notarizations allowed. Right now, I'm testifying before you because you have changed your rules, allowing for people to testify remotely. This is where the world has gone. Meetings often take place via Zoom and Teams rather than in person. So we, the IAC, is a member of a very broad coalition of interested parties. And from our perspective, the types of arrangements, transactions, and documents that are core and critical that must be addressed are the ones envisioned in Senate Bill 1040. However, we know that there are many stakeholders involved who want to have protective systems in place that deal with admittedly more complex transactions, real estate, as you pointed out, also trust in the state's powers of attorney and such. I will say that last year, the insurance industry felt a little bit of collateral damage because the debates and the conversations, which we were supportive of, led to the defeat of the bill. And we are still supportive of where that debate is going in terms of the real estate. But from a core critical business operational component, we are focused also on Senate Bill 1040. Just to be clear, both bills have our support. Senate Bill 1040 accomplishes what we do and what we need. One of the reasons the two bills look so different is Senate Bill 1040 tries to impact our existing notarization laws as little as possible and just allow for remote notarizations in those instances where, from our perspective, it is a critical need. And I understand the value in having a uniform law in place amongst all the states. Now, RELONA is not in place amongst all the states, but remote notarization is in place in nearly all of the states. So to answer your question, I have to be frank that 1040 accomplishes our needs.
If I guess that's the succinct answer to my question, but I still have the concerns that I expressed, and maybe we have to work together to cobble together something that's a little more narrow. But again, that I'm just one voice on this committee. Thank you, Mr.
I appreciate that, Mr. Senator Kissel.
Thank you. Comments or questions from other members of the committee? Comments or questions? Seeing none. Thank you for joining us again, Mr. George.
Thank you.
All right, we have Tom Gerard.
Thank you, Mr. Chairman, members of the Judiciary Committee. I appreciate the opportunity to speak to you. I am speaking in opposition to House Bill 6570. I'm an attorney in private practice. I do, as a large part of my practice, to defend Connecticut municipalities. I also work with the Connecticut Conference of Municipalities on a regular basis. And as many of you know, this is an issue that was raised last year. And I think the first normal question is, well, what's different between last year and this year? There's something very important that's different. And I want to bring that to your attention. The Supreme Court has decided a case known as Daly versus Cashmanian. And that is, I know there's lawyers on the panel, 344 Connecticut, 464. It was last August. And in that case, the Supreme Court put to rest an issue that was being debated last year. And that is, does this immunity that we're talking about for operation of municipal vehicles apply in non-emergency situations? Does it apply to the public works director? Does it apply to the plow driver? We heard that earlier this morning. Does it apply to anyone who's not in an emergency? And the flat out answer is no, it does not. So that issue was put to rest. There is no immunity for non-emergency operation. And that even applies to an emergency vehicle in non-emergency operation. A police officer on routine patrol has no immunity. An ambulance that's transporting someone from one convalescent home to another, not with lights and sirens, there's no immunity applicable to that. A fire engine returning from the fire without lights and sirens, there's no immunity for that. The Supreme Court has decided that. And so we don't need legislation to now say that. What's left, and this is still something that the Supreme Court is dealing with right now, is what about emergency vehicles in the course of an emergency? Right now, there is an immunity that will apply for certain situations, not for reckless driving, but we ask if that, and that's 14-283 of the general statutes. There is an immunity if an emergency vehicle has lights and sirens on, and in the case of a police vehicle, only the siren is needed, and is responding to an emergency and gives due regard for the health and safety of others around. It's a discretionary judgment to be made, and that discretionary judgment is not second guessed. Now, I want to say to you this, the Supreme Court is dealing with what is the scope of that immunity that I just laid out for you right now in a case that's pending before it. It's called Adesokan, Adesokan versus the town of Bloomfield, Connecticut. That's Supreme Court docket number 20753. And the Connecticut Trial Lawyers Association filed an amicus brief. CCM filed an amicus brief. The Supreme Court's about to tell us what the scope
Tony
and
Gerard,
extent is.
you've gone past your 3 minutes. If you could
All right.
summarize.
Be happy to answer questions about that. The message is, let's wait and see what the Supreme Court says, and then you'll know if you want to add legislation.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. Just fundamentally, let's set aside, the potential exposure to liability, but why do we want to have different standards? I, as an innocent human being who traveled the roads of various towns, I don't know why I want to give more deference to the aberrant driving of a municipal employee as opposed to someone else, like a state employee, because I'm going to be the injured party. And I think a negligence standard protects people. And if it's an emergency situation or some other kind of situation, or a police officer is cruising through the neighborhood, I think negligence should be the standard. I don't think it should be a higher standard such as recklessness or God forbid, malice aforethought. I just want to be protected as much as a reasonable person under those circumstances should exercise. And I think that should be the line. And what do you say to that as opposed to waiting for Supreme Court or other shoes to fall in this discussion?
All right, so first, to be clear, if it's a police officer cruising through the neighborhood, it's exactly as you say. He's the same as everyone else. So is the plow driver, so is the public works employee going from one place to another, the school bus driver, everyone. They are all the same. The only one who could potentially be looked at differently is an emergency vehicle operator, and this applies to state emergency vehicle operators as well, in the course of an emergency. What this legislature did in the late 1980s, it established a balancing proposition and said, we want you to get there quickly because these are our husbands, our wives, our parents, whoever, who are in the burning building or who have had a heart attack and need to get to the hospital, or who are had a home invasion and we need the police to come as quickly as possible. We want you to get there quickly, but we also want you to get there safely. And so if you consider both those and make a judgment, taking those into consideration, we won't second guess you. And that's the immunity piece of it. And so that's all we're asking, that we at least give the Supreme Court a chance to say, here's what we think about where that should lie. There's nothing left except emergency operators in the course of emergencies. Everything else is taken by the Supreme Court. And the state vehicles, state emergency operators have this same protection of 14-283. They are mentioned specifically, Department of Corrections vehicles in the course of an emergency, et cetera. So I don't think we should say we just want to flat out be the same as the state. We are all the same right now, except for those people going to emergencies. And I will tell you, the Supreme Court case right now for the town of Bloomfield, that was a woman and a child who were in the process of being abducted. And a police officer went to quickly and safely, and there was an accident. And because of the accident, there was a lawsuit. The court has the lower court said summary judgment. The Supreme Court is saying, let's tear this apart and see what we want to do with this doctrine. And so I think waiting would make sense.
I appreciate your advocacy for your position. And I have to clarify, state versus municipalities, but I will say this. If I'm the victim and, you can paint a picture, an example where they're responding and you can say it's hostage taking. It could be a terrorist. It could be the worst thing that we could imagine. Or it could be a false alarm, or someone's 911 went off in their pocket in their cell phone by accident. We don't know. And the fact that we're setting up a certain characterization of a person and we're not going to second guess them. And by the way, the use of the term second guess sort of makes it seem like we're a big brother looking over their shoulder. No, I think that people in the calm light of day can assess were the right factors put in there. And if I'm the one that is hit while the fire truck or the police car or the plow in a storm, if I'm the one that lost a leg for whatever that ultimately good or bad or emergency or not emergency, wherever they were going, I'm going to want some form of justice as well. And as I said to Mr. Anderson, I'm not intent on going after the individuals, but the political subdivision, I think, is fair game when we're looking at an otherwise innocent party that is harmed by circumstances through no fault of their own. And that's where you've given us stuff to definitely think about. I appreciate your testimony, but I can paint scenarios that go in the other direction just as easily. And my number one concern is the innocent victim in this process. Thank you, Mr. Chair.
Representative Fishbone.
Thank you, Mr. Chairman. Hey, Tom, how are you?
Hi, I don't see who's talking.
It's Craig. How are you?
Oh, hi, hello, Representative Fishbone.
Yeah, nice to see you again. The portion of this bill at the outset that I disagree with is the section 1, that it's applicable to any action pending on or filed after the effective date. So if we're changing an immunity level, in my opinion, if it goes into effect, it should apply to any act that happens after the effective date. So, but moving forward from there, looking at separation of powers doctrine, you're asking us to defer to the Supreme Court to determine what policy is in this state? Is that what I'm hearing?
It's what I'm saying is this, is that you may not need to take any action because the Connecticut Supreme Court might interpret where we are in this field in a way that you have no objection to and therefore feel no need to modify what's out there. That the Supreme Court also might say, according to how we read 14.283, this is where we think immunity lies. And then this group would then be able to react to that and say, well, we agree with it and we do nothing, or we agree with some of it, but we want to make something clear, and then you can go forward from there. But what I'm saying is right now, it's crystal clear that the snowplow operators, the municipal public works employees, the persons, even police, the police officer in routine patrol, there is no immunity applicable to that. There is no need for legislation to make that very clear, because it is very clear and it's decided. And we're also about to hear whether there's immunity for any other part of it. And that's what I'm saying. The Supreme Court may say, we don't think the immunity should apply to any motor vehicle. And regardless of whether or not in their emergency operation, and then you wouldn't need to pass legislation. But if you pass this legislation, it is a blanket removal of immunity in every single situation, meaning the judgment calls that have to be made. Because what will happen is the training to the emergency operatives will be, we've taken away the immunity. We know we're going to be sued every time there's an accident, even if we've given due regard to health and safety. So you know what? You can't go quickly anymore. They've taken that piece away. And so then the pendulum swings, and all of those, the people in the burning buildings don't want that, and the people who are injured, like Representative Kissel mentioned, they of course want that. They want to be able to sue. So we're in this balancing area where we have to find a balance. And the legislature in the 1980s spent a long time figuring out the tort reform and where the immunities would lie, and it survived all this time. So I'm thinking, that tread lightly's been mentioned an awful lot on the other statute. This would be a place to tread lightly on. Wait and see where it is. There are some possible unintended consequences. Many of our little towns have volunteers that do their fire and their ambulance response. Our cities are self-insured, the large cities. And so they don't just pass it off to insurance. This comes right out of budget. The training will be, you can't go there quickly any longer because we don't have the protection, and we can't afford the lawsuits.
So my intent with what we're working on here is parity. The municipalities should not have a higher right of immunity than that from the state, because the municipalities are creatures of the state. But how could it be so clear if we have to wait for the Supreme Court to opine? Isn't it our job to make it clear and go forward?
Well, if you're always free to if you have something clear in your mind to say what that is. All I'm saying is that the Supreme Court is about to make an announcement as to what the extent of emergency operation is. And so what your legislation is it's a modification of 52-557, which is the general municipal liability statute. It doesn't reference 14-283, and it's all, which is the emergency vehicle operation, and that covers state vehicles also. So I don't think it's decided that the state emergency vehicles don't get the immunity that has been found to exist in the discretionary acts of 14-283. That hasn't been decided anywhere. If you read the emergency vehicle statute, it says state police vehicles are covered by this emergency statute. Department of Corrections vehicles in an emergency are covered, etc. So now the state has given authority to sue for motor vehicle violations, and there's a collision there, right there, in laws, because I think that in an emergency, the state operators might be able to say no, that 14-283 is in conflict with this, and if it involves judgment and discretion, there should be an immunity. The state, the towns aren't the same. I know we get the power from the state. We aren't the same as the state. The state has theoretically, unlimited resources. We have volunteers. We have self-insured cities with huge budget issues. We don't have the same issues.
No, I agree. Municipalities in the state are certainly different. I'm looking for parity here. So I'm looking for us to do our job and not waiting for somebody else. So, but thank you. Nice to see you again.
Okay, sure thing.
Thank you, Representative Fishbein. Representative Blumenthal.
Thank you, Mr. Chair, and thank you, Attorney Gerard, for your testimony. So my question is, so you mentioned that there, obviously there are perhaps different considerations attendant to an emergency situation that might justify a different style of driving. My question is, wouldn't, if there were a litigation, the jury be able to consider all the facts and circumstances of that emergency situation, determining whether the individual who was an employee of the municipality was negligent in the first place?
Well, by rights it should, but the issue is the jury would an important defense would be taken away from the defendant, and that is that if it was a matter of judgment and discretion, then the defendant could say, I'm immune from being responsible for this. And the municipality would also say, I'm immune from being responsible. If we're talking about judgment and discretion, it's not a blank check. Reckless driving certainly would never be covered by immunity. So someone screaming through a red light at 60 miles an hour would never even have this doctrine applied. But it's just a matter of, do you want to defeat the paradigm that's been set up where we say we want you to get there quickly because those are important people who are, every second counts for, but we want you to do it safely. And if you do so, we'll give you a modicum of protection. We won't second guess. And then you're taking that part away, and you will then eliminate the conduct. Meaning
Through you,
you'll
Mr. Chair,
eliminate, we want you to get there quickly because they won't.
Well, through you, Mr. Chair, I appreciate that testimony, Attorney Gerard, and I appreciate your perspective. One of my concerns here is that if we have an immunity in these situations, then the full circumstances and facts never actually do get taken into account. And I think, often we remove an important incentive for municipalities to either have policies around safety in this area or to enforce them. You mentioned the importance of getting to an emergency quickly, and certainly we want municipal emergency personnel to get to an emergency as quickly as they safely can. But just as a demonstration, there's research that's come out that says often light sirens and speed are not the safest way for certain emergency vehicles to get to an emergency or to a hospital. And, from my perspective, I would like municipalities to have a significant incentive to pursue safety in all their endeavors, including emergency situations. So I'm concerned that immunity in that case would in some ways reduce that incentive. And I share Representative Fishbine's concern. I appreciate, as a lawyer, the idea of waiting for the court to act, but that they're really interpreting one of our statutes. And so to me, it makes sense for us to just say what we mean rather than to wait for the court to opine and us to decide whether they did it correctly. So I appreciate your testimony and your being with us here today. Thank you very much, Mr. Chair.
Thank you, Representative. Comments or questions from other members of the committee? Comments or questions? Seeing none, thank you very much for joining us.
Thank you.
Next, we have Mary Carmen Aparicio. Mary Carmen Aparicio. Beck Sear.
Hi there, I'm here.
Okay, you may testify.
Hi there. Greetings, Chair Winfield, Chair Staffstrom, Vice Chair Quinn, and Flexer, and members of the Judiciary Committee. My name is Beck Dangerous-Sear, and I am a resident of Norwich, Connecticut. Today, I'm speaking in support of House Bill 6569, an act concerning the minimum age to be eligible to marry. This semester, I will be graduating with my master's in social work from the University of Connecticut, and I have been involved in anti-violence work for the past 4 years. I'm also an ordained minister. Over the past 4 years, I have had the pleasure of once working as a prevention educator, teaching thousands of Connecticut K-12 students topics such as consent and healthy relationships. I recall having conversations with students about the age of consent and can count the number of times on my hand where a student asked about age in the context of Connecticut statutes pertaining to marriage. However, I remember explaining to students that legal doesn't always mean healthy. For example, in the context of relationships, students easily understood that while a 16-year-old is at the age of consent, if they were to be dating someone much older, perhaps in their 30s, that this raises significant red flags around power and control. You have already heard from subject matter experts across the country, such as Unchained at Last, regarding the nuances of child marriage and the many reasons why a child may be forced or coerced into marriage, as well as the legal loopholes that still exist in Connecticut statutes, allowing this practice to continue in the year 2023. I believe that the age to be eligible to marry should be raised to 18 years of age without exceptions, and this bill would finally address the majority of children that enter child marriage. If the teenagers I spoke with could understand the unhealthy aspects behind relationship dynamics like this, then it's time that Connecticut laws get on the same page. I also hope that the passage of this bill motivates the state to re-examine and collect data regarding the age of consent as well. In addition to what you have heard today, I want to add that child marriage often disproportionately impacts marginalized children, including LGBTQ children. Reports from the Human Rights Watch and Freedom United last year included stories from survivors of child marriage who state they were forced into marriage after their family discovered they were LGBTQ and believed that forcing them into a heterosexual marriage would cure and fix them. I bring this up because while we have successfully banned conversion therapy here in Connecticut in 2017, current statutes pertaining to marriage could be taken advantage of in this context. As a proud non-binary person who has also worked with queer youth, this concerns me. With the rise in transphobic and homophobic legislation across the country, particularly targeting young people, I think this bill would help keep Connecticut on the right side of history. Thank you again for the opportunity to testify, and I'm happy to discuss this further. Thank you to the committee for taking on this important issue, and I urge you to vote in favor of House Bill 6569.
Thank you. Comment, question from members of the committee, Representative Dubitsky.
Thank you, Mr. Chair, and thank you for coming in. Do you know what the minimum age to get an abortion is in the state?
That I do not know.
I'm sorry, I didn't hear you.
That I do not know.
Do you know, you work with LGBTQ youth, is that right?
Correct. In the past, I have experience working with queer youth.
Okay, do you know what the minimum age for surgical transition is?
In the state of Connecticut currently, I do not know the current age, but I know that it's usually approached by a case-by-case basis. It also depends on the procedure. If we're talking about hormone replacement therapy, simply if we're talking about gender affirming surgery, such as top surgery or bottom surgery, it's usually a case-by-case basis between parents, the practitioner, and the child in question.
I'm sorry, could you explain what top and bottom surgery is? I'm not sure what that means.
Sure. So top surgery being any type of procedure that may alter the aesthetic presentation of the chest or the upper body. It looks different for if someone was a trans man or a trans woman, or if someone was non-binary. Bottom surgery pertaining to surgical procedures involving genitals. And that could be different if it's a trans woman, if it's a trans man, if someone's non-binary. It's kind of a case-by-case basis what the goal would be for bottom or top surgery.
Okay, so under Connecticut law, are there any circumstances under which a child can have top or bottom surgery at the age of 16?
You know, that is something that I'm not quite sure about. Usually with my experience, I would talk to parents about hormone replacement therapy. And that's something that a minor can receive in Connecticut.
Okay, so hormone replacement surgery means they get, a girl would get testosterone and a boy would get estrogen. Is that right?
Correct. And that's not a surgery. That is a hormone injection.
Okay, and those are, you can do that at 16?
Yes.
Okay, but you wouldn't be able, but under this bill, you wouldn't be able to get married.
Yes.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us.
Thank you.
Next, we'll hear from Tim O'Keefe.
Good afternoon, Chairman Winfield. Good afternoon, Chairman Staffstrom, Ranking Member Kissel, Ranking Member Fishbein, other members of the Judiciary Committee. My name is Tim O'Keefe, and I have the honor of serving this year as president of the Connecticut Trial Lawyers Association. I want to start by thanking all of you for the opportunity to address your committee on two issues of great importance to the CTLA, and certainly would invite any questions that you have on these or any other issues. First, the CTLA opposes Ray's Bill 954, which is a bill that seeks to overturn the Connecticut Supreme Court's decision in Marciano versus Jimenez. My colleague, Brendan Faulkner, has already addressed that proposal in much greater detail when he spoke earlier. That decision was released in 2016, and things have worked very well since. When you review the proposed bill, I would simply ask that you keep in mind that it is exceedingly rare when an insurance company is actually a party to a case where these post-verdict issues are being addressed. The cases most often involve a party or company that has already been found by a jury or court to be legally liable for harms and losses caused by negligence, recklessness, or intentional misconduct. And we're not just talking about driving, drunk drivers, and distracted drivers. These liable defendants include manufacturers and sellers of defective products, trucking companies that hire bad truck drivers and don't train them properly, defendants that have sexually assaulted and molested children, pit bull owners who do not properly restrain their dogs, companies that pollute and injure, companies that sexually harass and discriminate. The collateral source rule existed at common law to make sure that these types of defendants are held legally accountable for the full value of the harm caused, as tort law is designed to prevent these types of misconduct. We hear a lot in this debate about the notion of double recoveries, but we don't seem to hear enough about the defendants that are seeking to benefit from reduced judgments, which is an issue that was addressed directly by the Supreme Court in the Marciano decision. So I would urge you all to vote no on Raised Bill 954. In addition to that, I want to express CTLA's strong support for Raised Bill number 6570, which is an act that would address the disparate treatment given to negligent operators of motor vehicles when those vehicles are owned and insured by the towns and cities of our state. The same exact proposal overwhelmingly passed both chambers last year. It passed unanimously in the Senate. It passed the House with only one no vote, and then the bill was vetoed by Governor Lamont. We respectfully submit that the sound public policy decision made by this committee and the full legislature last year should be reiterated, and the bill should be passed again. The same issues raised by those opposing this bill were raised in committee last year. I would urge you to pass the bill, and I'm happy to entertain any questions that you might have with respect to that bill.
Thank you, Representative O'Day.
Thank you very much, Mr. Chair. Good to see you over there, Tim.
My good friend, Representative O'Day, nice to see you.
Yeah, I just want. No, congratulations on your being the president of the Connecticut Trial Lawyers Association, a group that I hold in high esteem. Just a quick question on the Marciano. You said it's rare. I mean, would you agree there was some testimony that it does impact settlement negotiations? The fact that there is a, I don't want to call it a inflated amount of medical bills, but how would you address the concerns that have been voiced that there are bills that go out that aren't actually charged? In other words, there's, the insurance companies pay much less than what's actually billed. Would you call that a windfall? How would you explain the difference?
I wouldn't call it a windfall at all, Representative O'Day, and thank you for the question. It's a good question. Marciano settled law. You had actually asked earlier another person testifying, what happened before Marciano? Well, what happened before Marciano was what Marciano settled. Most often, there certainly was a split of authority amongst our superior courts, but most often what Marciano ultimately decided is exactly what was decided. A policy judgment was made by this legislature years ago in favor of holding wrongdoers fully accountable for their harms and wanting tort law to actually work, and that is the prevention of future harm. So in those rare occasions where there may not be a full reduction, and as you asked in this question, if we're going to have to choose between fully compensating an injured party versus not fully holding a wrongdoer accountable, we're going to choose to hold that wrongdoer accountable. And that's simply what Marciano stated. And that's the policy that underlies its decision ultimately.
Thank you for that. And in House Bill 6570, I was the lone no vote in the House and the Senate, and the governor seemed to agree with me. But happy to put that on the record. Yes, the governor and I see eye to eye on a lot of things. And so, but in any event, as I understand the argument, some of the concerns of my colleagues here is that particularly about the state vehicle, say, versus the municipal vehicle and the disparate treatment between the two. if 6571, I'm sorry, 6570 would apply to both state and municipal vehicles, I assume you'd just have a similar problem with that. Is that fair to say? In other words, the concerns that have been voiced by my Senate colleague is that we're and my ranking member colleague that we're treating the municipal vehicle differently than the state vehicle.
Absolutely. And that is the crux of the problem that we're looking to address. And I will say this, I heard Attorney Gerard, whom we all know well, is a very good lawyer, very astute lawyer, talk about issues raised with respect to 14283. I want to get it on the record. The statute covers those scenarios already. If you take a look at 52-557N, we already have the phrase except as otherwise provided by law. And that would allow a judge or a trier of fact to instruct the jury properly with respect to what 52-283 already says. So I wanted to make sure I addressed that issue. With respect to concerns raised on volunteer firefighters and volunteer ambulance workers, there already is an indemnification statute which holds those people fully harmless in these scenarios. Driving is driving. Driving is driving. And as Senator Kissel pointed out, the best way to judge people with respect to these issues is by a negligence standard. Different circumstances will dictate what due care requires under those circumstances, as you know. In other words, an emergency situation may be judged ultimately differently than a public works person who chooses just to run a red light while he or she is doing his job in a particular town. But all of those issues raised by the opposition are already fully addressed by current law.
You heard Attorney Gerard talking about the Daly case and maybe holding off. Would you agree with that opinion, or what is your pause on waiting until after Daly's decided?
We don't agree with the opinion. The reason we're here is because for 30 years, our appellate courts have whittled away at injured parties' rights to pursue justice in situations involving negligent driving. Little by little by little by little, that's occurred. I can't comment on the facts of that particular case. I'm not familiar with it. So I don't want to get into the
And I misspoke. It's actually the Bloomfield case that is.
I heard that as
Sorry.
well. Yeah,
Sorry.
I'm not familiar with that particular case either. But I don't think that decision should replace the public policy judgment that this body made last year and should on its own make it. Our position is it's your job to do so.
Fair enough. Well, thank you very much. It's good to see you.
Nice
And
to see you.
thank you very much, Mr. Chair.
Thank you very much. Senator Kissel.
Thank you very much, Chairman Winfield. Great to see you again as well.
You
And
as
you
well, Senator Kissel.
articulated my positions far better than I have done this morning. But thank you for the shout out. On the first issue, that bill, and you said you're urging us to vote no, and that's if it indeed it comes up for a vote. But that's an issue that's been before us in the past as well. One of the new things, though, that was thrown out here, and I don't want to necessarily call it a red herring, but I think it was Louisiana and another state was referenced about bailouts and like their entire insurance industries collapsing because we don't have what they have or something like that. And on that one, I think the situation has been working out just fine. I think that it is a policy decision, and if there's going to be a net benefit, where should it go? If it's going to go anywhere, and it shouldn't go to the party on one side of the equation, it should go on the plaintiff/victim side of the equation. But regarding this whole collapse of the insurance industry and bailouts, do you have any comment on that? That where did that come from? Is that just like a last Hail Mary pass by them?
Perhaps it is, Senator Kissel, and thank you for the question. I really don't know. I have not seen such data. I think we're talking mostly about the automobile insurance markets, which are very competitive in our state. And I think as it relates to this issue, I think the fact that Marciano has been settled for so many years and the fact that even before it was settled by our Supreme Court, that most superior courts dealt with these issues the way it ultimately decided. I think the prices have already been baked into the price of automobile insurance already. I think the premiums already reflect that. If a change were made, perhaps an argument could be made that the windfall would inure to the benefit of the insurance industry. But again, I don't have enough data to comment on that issue.
Okay, thank you. And on the other issue, which again, I was trying to debate, I'm with you. And I want to thank the trial lawyers in Connecticut for championing the cause of the victim. If I'm walking across the street or if I'm in another car, I really don't care, if the other person in that other vehicle that struck me and injured me or my loved ones, and God forbid it's a fatality, negligence is negligence. And I don't want to do anything that would undermine an ability to respond to an emergency. I get that. And that tugs at our heartstrings because we think about, if your elderly mother or grandmother, is laying there, or if there's a hostage situation or a terrorist, we don't want our state or local folks, volunteers, whatever, the emergency folks to slow up. I get it. But if you're caught in that crossfire, if somehow you're just the innocent parties at the wrong place at the wrong time, you need justice too. And our judicial system should be always striving to make sure that everybody is made whole to the greatest extent possible. And unfortunately, we can't go back and reverse time. So all we have is that fungible good called money. And we try to do the very best we can within the limited means that are at our disposal. And to my mind, these are new arguments. They're like doubling down in opposition to this bill. But fundamentally, aren't we just treating the goose like the gander and trying to make it an even playing field? And we want to assure the public, our constituents, that no matter who the perpetrator of that action is, and I'm not saying they had a bad intention. We're not saying malice or forethought. We're not even saying recklessness, but we're saying that if you take the totality of those circumstances, a negligence analysis, and saying, for that period of time, a reasonable person responding to an emergency with that kind of latitude, with that kind of field of vision, in that kind of weather, with those kinds of tires, all of those things, it's either acceptable or unacceptable. It's either verdict for the defendant or verdict for the plaintiff. And that's built into the settlement discussions as well. And do you see anything that has changed since Governor Lamont's veto of the previous bill that has changed, or you have already articulated that we shouldn't wait for a judicial decision, that policy that you were promoting last year is the right one? We had it unanimous in the Senate, unanimous in the House, but one, and nothing has changed to try to undermine our confidence in moving in that direction this year. Would that be fair to say?
I think it is, Senator Kissel. I think there have been no changes at all substantively, as you point out. And ultimately, it is an access to justice issue fundamentally. The same standard that applies to a state employee operating a vehicle should apply to a municipal employee operating a vehicle. The same standard that applies to a private citizen operating a vehicle should apply. Again, a totality of the circumstances analysis will ultimately be done by the trier of fact, but the access to justice needs to be there for all injured people, and that's the position of the CTLA.
Thank you very much, and I appreciate all your effort and the effort of your membership fighting for justice here in the state of Connecticut. Thank you, Mr. Chair.
Thank you. Comments or questions from members of the committee? Representative Blumenthal.
Thank you, Mr. Chair, and I will not stretch hopefully too far the limits of the chair's indulgence. A lot of my questions have been answered by you and by others, so I'll try not to repeat them. I just wanted to give you an opportunity to respond to a statement that was made earlier with respect to the fact finder's ability to judge whether the medical bills as alleged or proven were reasonable. And I was wondering about your experience or understanding of whether that reasonableness inquiry can or does take place.
It can and it does, and we give that power to our triers, to our Superior Court judges to do just that. That happens quite often, actually, in cases that I know that I've been involved in terms of trial. So it's a very common circumstance in our superior courts. Thank you, Representative Blumenthal.
Thank you for that answer. And through you, Mr. Chair, one more question. We heard some testimony about fact finders not knowing about whether these bills were actually paid, and how that might affect their judgment. We don't tell juries a number of things, and lots of us disagree about what those things should be. But one of them is that we don't tell juries is that in many cases it's insurers rather than the individual defendant who will be paying the judgment. What is the rationale for that rule, and how do you think it affects trials and verdicts and the like?
Thank you, Representative Blumenthal. That has been the rule for as long as I've practiced, and I've been practicing for over 30 years. It's one I happen to personally disagree with, the rule that doesn't allow the fact finders to understand that certain defendants are insured or whether or not they're insured. However, so to answer your question directly, I think the rationale to make the argument on the part of the side that I don't agree with is that we want to leave it to the fact finders to decide issues related to negligence, proximate causation, and damages, separate and apart from whether or not the defendant is insured, because I guess arguably the existence of insurance could impact how they decide those fundamental questions in a particular case. So again, putting me in a position to take a position I don't want to personally take, but it is the common law, and it has been for quite some time, and it's well known in our jury instructions.
Well, I appreciate your answer. You did a better job of representing the contrary interest than I would have. I think one of the rationales, it may not always be stated fully, but is that juries might give more money if they knew that the individual defendant was not going to be paying it, if they knew that there was insurance that was available. They might give damages. They might give the full amount of the damages and may not consider whether the individual defendant may face damage to their business or their lifestyle or whatever may apply. So, I guess the point I'm making is that there are things we don't tell juries on both sides of the equation. There are various policy reasons for those things. The litigation process and the trial process are not perfectly efficient, but I certainly am sympathetic to your position that this is one situation where it makes sense to put whatever net benefit there is out of medical bills that are negotiated down in the column of the plaintiff rather than the wrongdoer. So thank you, Attorney O'Keefe, and thank you, Mr. Chair.
Thank you. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us.
Thank you very much.
Mike Riley.
Thank you, Chairman Winfield. Representative Staffstrom has returned, thanks be to God. Senator Kissel and Representative Fishbein. I'm Mike Riley. I'm a registered lobbyist, but I'm not here to represent anyone except some people that I never represented at all, but who are subject to a bill that will increase significantly the fine for commercial vehicles operating on the Merritt Parkway. I served for 29 years as the president of the Motor Transport Association of Connecticut, and this issue arose most dramatically when GPS systems began to shunt people through the country, and some independent owner operators purchased GPS systems that worked for cars, and they would actually direct them onto Route 15, and often those people didn't realize that they were breaking the law. Frequently there were a lot of calls to the state police, a lot of calls for something to be done, and fine bills have been introduced in this body before to hit people $500 for their first offense, which I think is excessive for some people that are just trying to run a small business. They're not maliciously trying to get away with anything. They're directed to where they're going through technology that seems like it works everywhere else. So the last time I testified before this committee was in, I think, February or March of 2019, when this bill was before this committee. Only at that point, it was a $150 fine for the first offense and $500 for each and every subsequent offense. I think the fine now is, I think, $80 or $90. Increasing to 150 makes sense, but and if anyone is stupid enough after they get $150 fine to go back on that highway, you should hit them for $500, and you should hit them for $500 every time they try to pull that off. I represented 500 to 700 companies from time to time, mostly based in Connecticut or operating in Connecticut. Connecticut people don't go on the Merritt Parkway or Wilbur Cross Parkway because they know it's holy ground, and that there are also the potential to hit bridges is higher, and the enforcement just scares them away. So I think the people you're talking about are not the people I ever represented. I don't represent them now, but I think that to hit people with a $500 fine for something that they didn't necessarily do on purpose is excessive. And I would urge you to go back to where this committee was when I testified in 2019, which is a $150 fine for the first offense and $500 for anything after that. That concludes my testimony.
Thank you. It's really good to see you again. How often do you drive on Merritt Parkway?
I don't. I try not to. I hate that road.
Right. But there's a number of us who don't have that luxury, who have to drive on the Merritt Parkway or the Wilbur Cross in order to get here, and drive that road almost daily in order to get here. And I'm looking at my colleagues from Fairfield County who are here. And I think we will all tell you there is almost not a single day that goes by that we drive up here that you will not see a truck on the Merritt Parkway on the way up or the way back. It is not a rare occurrence. It is not something that just sort of, oh, gee, it happened once and, you know, gosh, I can't believe we're making a big deal about it. But it is almost a daily occurrence. And when a truck does get on the Merritt Parkway, as you referenced, they can't fit under the bridges. So what then happens is the road has to be shut down with several state troopers who then have to back the truck up to the last exit to get them off while they close the highway. And the loss of productivity to the state of Connecticut in terms of the trooper manpower and the number of folks who drive that road to get to and from picking up their kids or to work or whatever pales in comparison to $500 fine. And I think we have spent the entire day here today talking about how to allocate risk between, you know, should it be this side or that side? Who gets the benefit of whatever? At what point does the trucking industry, we put up a whole bunch of new signs. At what point does the trucking industry say, I can't just zone out looking at this and follow it, and that I have an obligation to actually read that sign? And if I don't read that sign and it causes a 2-hour traffic jam on the Merritt Parkway, that I'm going to be responsible for that, which would be thousands of dollars, maybe tens, hundreds of thousands of dollars in lost productivity to the state when that happens every day. But we're talking about $500. We're talking about something that would cover, I don't know, maybe the police overtime needed in order to get that truck off the highway. You know, I understand your perspective on this. I don't think anybody's trying to pick on somebody who makes a mistake, but we are talking commercial vehicles who do this repeatedly. And maybe it's not the same person, maybe it's not the same company, but it is a repeated problem. And if you know, in 2019, when you testified against going to $150 at the time.
No, I swallowed that one.
Did you? Okay, all right, I stand corrected. The, you know, the thought was, and I kept hearing, well, put up more signs, put up more signs, well, the DOT has done that. They put up big, bright, orange, yellow signs that say, no trucks, you know, it's still a problem. And I just think until there is sort of a passing of the risk for doing it, because trust me, I mean, for $80, if it's going to save you, okay, maybe I'll take my shot. You know, I don't think we can rule out that that's happening.
Mr. Chairman, I'm reminded of the gladiators' statement as they entered the arena. Hail Caesar, we who are about to die salute thee.
I'm gonna, Senator Kissel, before you, I'm gonna defer to somebody else who I know suffers from merit truckitis, Representative O'Day.
Yeah, so I am at a pause as to how to respond as well. But I do, it's great seeing you up there. And I, as someone who actually has a picture, I was looking for it, of a tractor trailer going the wrong way on the Merritt, the wrong way. I'm going to find it and send it around to the committee. But I do, in hearing both sides, I think maybe something along the lines of 150 or 250 and then 1,000 to emphasize the point. But to Mike, who's been doing this for so many years, I certainly defer to your judgment on kind of balancing and you know, I do have concerns of it going right from you know, where it is now to up to 500 right off the bat. But we do have to do something, and whether it's putting up better signs, I'm not sure the 500 right out of the gate is the right thing. I'm thinking about it, but we do need to do something, because the good chair is correct. We are seeing too many commercial vehicles. I've literally pulled next to him, honking my horn to get off, and I've taken my state plates off because I've gotten tired of getting yelled at because of my state plates being on, and people are happy with that. But we do need to do something. I totally agree with my good chair, and but I also see the argument about going right from where we are to 500. That hopefully we can compromise on it, but something needs to be done, and I agree. Thank you very much, Mr. Chair. And I certainly didn't mean to jump my good ranking member.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Representative O'Day, it's you're suffering through this all the time, so you definitely have paid your dues. You know, I'm glad you told us that it was 2019. Mr. Riley, Michael, it's just great to see you. And I was going through my mind, and actually that's why I was able to vouch with the good chair that you were supportive of $150, but I can definitely sense the angst in his voice of having to deal with this. And signage apparently isn't doing it. It's funny when you said the Merritt is holy ground. I mean, I'm lucky enough that I have 91 North, and we don't have any of those issues. We have trucks galore, but it's designed for that. But when you said holy ground, if I recalled how you were dressed for the late Senator Doc Gunther's testimony about the AquaTurf once upon a time. And if 4 years ago seems like yesterday, that was probably much longer ago. But you were a fixture here in the building. It's great that you still have an interest in this bill in particular. But we want to make our chair happy. And so he is the Caesar of the moment. And there has to be something that can be done to remedy this. You use the whole notion of like the automated, but 4 years have passed, and you know, pretty soon we're going to have those jetpacks that we were all promised when we were little kids, just zooming around. So we're going to have driverless cars before you know it. So something has to be done for these poor gentlemen and ladies that have to make that trek. But I just want to say thank you for keeping an interest in the legislature and voicing your wisdom for all of us. Thank you.
Thank
Thank you.
you.
Mr.
I don't
Chair.
understand why these signs don't work. I can't figure it out. And is there active enforcement on that highway? Are they pulling trucks over and ticketing them?
I call 911 every time I see one.
And you ain't the only one, apparently. They say that the switchboard at the state police headquarters, when a truck goes on that highway, lights up like it's a nuclear attack. But they don't get pulled over.
Well, the question is whether they get to them before they hit a bridge. And so to Representative O'Day's point, I usually honk, I call, and they can go a certain ways down, but what happens is depending on, some of those bridges are too short and they get stuck under the bridge, or a lot of those off ramps are very sharp. So if they do try to come off, that's when you see them flip over because they can't make the turn off those off ramps.
Yep.
All right, further questions or comments? Yes, Representative Blumenthal of Stamford.
Thank you, Mr. Chair.
I'm
As
surprised that you
another
have a
Merit dweller.
question.
I appreciate you being here, Mr. Riley, and appreciate your testimony. I understand your point of view that you think a jump straight to $500 fine is perhaps unduly harsh. I won't belabor the points made by my colleagues who are fellow Merit dwellers and have made them eloquently. I think at the end of the day, I think a lot of our attitude is that we've tried a lot of things on this subject and nothing has worked. Nothing has gotten better. I know the GPS is a part of the problem and we'd love to be able to do something about that. Unfortunately, at the state level, that's pretty difficult. And unfortunately, at the federal level, there's, lots of probably legislators across the country who don't care very much about the Merritt Parkway.
But there are now GPS systems that accommodate the needs of the trucking industry and indicate where they can't go. So my argument about the car GPS is getting a little long in the tooth. I realize that, but there are still people that are using the old GPS systems. It's a puzzlement. The whole thing is a puzzlement.
Well, I appreciate that. And to me, I think that having a higher fine, especially when you have a trucking business that has more resources and lots of drivers on the road, it provides us more significant incentive to get one of those GPS systems that can make those accommodations. And I guess my question to you would be, I understand you saying, a first offense should be $150 and second $500. What would your attitude, are you okay with that being per business or owner rather than by driver?
It's the driver that's doing the violation, and it is the driver that ought to pay the fine, not the company.
But I understand that, but isn't the company responsible for training them? Aren't we going to get better results if we give an incentive to companies to take their employees by the lapels, shake them and say, do not go on the Merritt Parkway?
I think giving an employee a fine of $500 gets their attention. But I think the same thing happens if you hit them with a $150 fine. If you don't find the driver, what does he care? He'll take a shot, maybe. So, the driver has to feel the pain, not the company. The company can yell at him when he comes back, but in the end, they've got to pay it.
Well, I appreciate your perspective. Personally, I think I disagree on that point. I'd like the company to be talking to them beforehand. I think in some ways it's, hopefully the drivers that are making an honest mistake because maybe they don't know beforehand, but certainly a company that has a bunch of trucks on the road should be aware of the situation, should be enforcing it with their drivers, should be, training them up on the situation to keep them off the Merritt. And I think we have to do something to provide an incentive for companies and drivers to keep commercial and trucks and other vehicles off the Merritt, because as the good chair said, it is a tremendous cost to our state, both through the direct resources that are spent to get these vehicles off the road, but also the loss in productivity, and we're all bearing it. So I appreciate you being here today and your testimony. And
I don't disagree with you. I just think that you hit a guy with a $150 fine, you got his attention. If he does it again, hit him $500. I have no sympathy for a guy that does that, but some of these people don't make a lot of money. They're living in their vehicle. and they are trying to save money however they can. They'll take the most direct route, I think, to save money. And then when they find out that they're subject to $150 fine, they say, well, I'm not going to go on that again. But when you're taking away somebody's family's income there for what may not be a malicious motivation on his part.
Thank you, Representative Fishbein.
Thank you, Mr. Chairman. I don't travel the Merritt Parkway very often, 91 frequently. But there's another way to attack this. If we're concerned about the amount of the fine, you could perhaps deal with how the fine is paid. Because if you levy the fine against the driver just turns around and says to the business, it's your responsibility. Both of those payers of the fine are going to be able to do that electronically. Now, I believe the electronic payment of fines is based upon statute or regulation. So we could say that it's got to be paid in person. And therefore, yeah, 150, but you got to go and pay it. And therefore somebody is actually having to do it. So it's another way to look at it, and maybe even more painful than the higher fine. So, but I agree. Everything I've heard, we need to do something. So thank you, Mr. Chairman.
Representative Fishbein, where do you propose the fine be delivered to?
Wherever it gets paid electronically to now.
Mike, great seeing you. Thanks for being with us.
Thank you.
Becca Powell will be next. Ms. Powell, do you drive the Merritt Parkway frequently?
No, I am from New Jersey by way of Pennsylvania. Good afternoon, everyone. My name is Becca Powell, and I am the Director of Advocacy and Outreach for Unchained at Last. We are a survivor-led nonprofit that's dedicated to ending forced and child marriage in the United States, and we also convene the Connecticut Coalition to End Child Marriage. And I'm here today to testify in strong support of HB 6569. And I want to address some questions that have come up so far today in the discussion surrounding this bill. Representative Osborne, you brought up the question of religion, and I want to let you know that Unchained at Last has worked to end child marriage across the U.S., and we have received strong support from the interfaith community. In Connecticut specifically, the Catholic Conference is neutral, and the Interfaith Council of Southwestern Connecticut is a member of the Connecticut Coalition to End Child Marriage, which we convene. We actually don't know of any religion that requires child marriage. And even if there was a religion that required child marriage in the United States, the Supreme Court has upheld that legislation that incidentally forbids an act required by a religion the Supreme Court has upheld that legislation that incidentally forbids an act required by religion as long as that legislation doesn't target religious practice. And that's the Oregon v. Smith 1990 case regarding peyote. Additionally, I wanted to address the discussion about improving, in quotes, the process of entering minors into marriage by using court-appointed attorneys or guardians ad litem. In 2017, New York tried allowing child marriage with court-appointed attorneys. And in 2021, New York ended child marriage, acknowledging that even with court-appointed attorneys, minors were still being forced to marry. And lastly, I just want to touch on Representative Fishbein's concern about child marriages involving service members. Two groups submitted written testimony in support of this legislation. They are Protect Our Defenders and Service Women's Actions Network. Those are two service member groups that are writing to urge you to set the marriage age at 18 with no exceptions. At Unchained, as I said, we are direct service providers to those who have been forced to marry. We have worked with survivors who are forced to marry service members, and they deserve the same rights of minors who are being forced to marry civilians. So I thank you so much for your time, and I'm happy to answer any questions.
Questions from the committee? Representative Fishbein.
Thank you, Mr. Chairman. In your written backup, your testimony, you make this statement: child marriage is an urgent problem in Connecticut. What is we heard today, unless you know, the 31, assuming that to be true, cases since October 1 of 2017, which, if any of those, is claimed to be a forced marriage?
So as it's been said today, we don't have any data besides the names of those who were entered into marriage since October 1 of 2017. But what I can tell you is that child marriage can easily be forced. And it's not a question of maturity. It's essentially a question of legal capacity. Even a day before they turn 18, the most mature minor can be forced to enter into a marriage. And that's simply because they don't have the full rights of adulthood that they would receive the day that they turn 18. They can't even simply leave home to flee an impending forced marriage because they'll be taken right back home by a police officer. And even if there was anywhere for them, even if there was a way for them to get away safely, there isn't really anywhere for them to go because domestic violence shelters across the US typically turn away minors. They could go to a youth shelter, but those stays are typically limited to 21 days. And they're also typically not confidential. They have to, tell the parents where the person is. Even before they turn 18, a minor can't easily, retain an attorney because contracts with minors are voidable. So while we don't have that exact data for those minors who were married between October 1 of 2017 and today, we do know that they can easily be forced. And as it has been said before, even just one minor being forced into marry is an urgent atrocity that has to be addressed. It has been addressed by every single one of Connecticut's neighbors, as has been testified today. Every single one of Connecticut's surrounding states has ended child marriage. There is legislation pending in Maine as well as Vermont. And so if Connecticut doesn't act this session, it will quickly become the destination site for child marriage in the Northeast.
Okay, so can you identify one marriage post October 1, 2017 that you would characterize as a problem?
As I said, I don't have the data about those specific marriages. I do know that Representative
All right,
Cook.
so the answer is no, you can't identify any.
I don't, but I can tell you that Representative Cook
So-
has spoken to, I believe, the governor's office. She
she's
was
not-
trying to get
she's-
data
she's
regarding
not
that.
here.
Folks, I'm gonna jump in.
Oh, sorry.
We do have to make a transcript of this, et cetera, so we're gonna have a question and then we're gonna allow the questioner to finish the answer and we're not gonna interrupt the question. All right,
I
so
apologize.
Representative Fishbein, you have the floor, like to pose a question.
Thank you. So I have spoken to Representative Cook and I've had those discussions and that hasn't answered the question either. So if you can't identify any case post October 1, 2017 that you would characterize of the 31 or perhaps others that is a problem, then how do you make the representation in your written testimony here today that it is an urgent problem? How do you make that representation?
So the reason why it's urgent is because it can easily be a forced marriage. I can't say for sure if any of the ones from October 1 of 2017 to today have been forced, but I can tell you they easily could have been forced, and any marriages in the future, if Connecticut doesn't end child marriage this session, can also easily be forced.
Okay, thank you. Have a good day.
Thank you so much.
Further questions or comments from the committee? Vice Chairman Quinn.
Thank you, Mr. Chairman, and it's nice to see you in person. Obviously, I was pretty moved by what you had to say during our online conversation and did sign on as a co-sponsor to this. However, I think that the emancipation question that was raised earlier, it needs to be looked at a little further, because if we're going to entrust the probate court to make the decision that a minor meets all the legal standards to be emancipated, I don't get how, on the other hand, we could say you can do all these other things as an adult, but you can't get married. So I think that we need to revisit that, and perhaps an exception is in play with a person who has gone through the emancipation process, because clearly a court has deemed that they are able to make adult decisions, and marriage would be an adult decision.
Well, first of all, thank you for your support. Greatly appreciate it. And thank you for that question. As has been addressed today, there is no reason to allow emancipated minors to marry, because it is not a right that they need to navigate the world as an adult. And additionally, there's no reason to create a loophole, or sorry, to retain a loophole under which a minor who is emancipated can be entered into a marriage. Simply because if that loophole exists, then it is possible that Connecticut could see minors being forced to marry, it could see minors being forced to emancipate in order for them to be forced to marry. At Unchained at Last, we have seen parents go as far as to commit murder to force a minor to marry. We absolutely believe that they could force their child to emancipate in order to force them to marry.
But I mean, again, a probate judge is going to be making the decision. And I think we have to put some faith in our probate system that the judges are asking the right questions in order to reach the legal conclusion that they are eligible to be emancipated and do all of the other things that they can't do as an unemancipated minor, except for this one thing.
I would say while the probate court judge could ask any number of questions to try to determine if a minor is not being coerced or if they are entering into a marriage freely. But what is impossible to control for is for that home life where a minor who is being forced to marry, typically by their parents, is being coached on what to say and is being threatened with all manner of things if they deviate at all from that script. I don't believe there's any questions that the probate court could ask that could effectively screen 100% of child marriages. So the solution is not to think of a better way to enter minors into a marriage. The solution is simply to set the marriage age at 18 with no exceptions. And if an emancipated minor is in love and they want to marry and they're 17, there's no harm that comes from them waiting just a few more months until they're 18 to be married. You know, we say that a minor has to be 18 in order to do all manner of things in this country, whether it's vote or buy a gun. They have to be 21 in order to purchase alcohol. All we're saying is that, set the marriage age at 18 and delay that right even for an emancipated minor who might be marrying for all the same reasons in order to protect those who might be being forced into being married.
Thank you.
Thank you.
Further questions or comments from the committee? Further questions, comments, Representative Osborne?
So thank you, Mr. Chairman, and thank you for being here today. This is an important topic. And obviously the idea that a child's parents would murder them rather than not have them enter into a child marriage is an atrocious situation. Did that occur in Connecticut?
I'm not able to share any details about any clients that Unchained has worked with. So I can only say that the anecdotal
client
evidence
is dead now, whoever that is, correct?
Say that one more time.
That person is dead. You said this person was murdered by their parents.
What I said was that we have seen parents go as far as to commit murder in order to force a minor to
So
marry.
have you seen a parent go that far in Connecticut?
I can't say for certain if it was in Connecticut. Unfortunately, I don't have that information in front of me.
Can you say whether it occurred in Connecticut after October of 2017?
I can't say that for sure, unfortunately.
So that's a pretty alarming case. And I think I might remember that about where it occurred. Do you just not, are you not comfortable telling me, or do you not know where it is?
At Unchained at Last, we can't discuss any of the details of our clients. Unless that client were to be a survivor who wanted to publicly testify about their own story.
But you're saying that this client is dead.
I unfortunately can't comment on that.
I'm going to take a leap and say this is not an post-October 2017 case in the state of Connecticut. I'm comfortable saying
I can't say for certain.
I think I would have heard about that. So my question is, you also said that if we don't pass the law that you want passed in the state of Connecticut, Connecticut is going to become a destination for child weddings.
Mhm.
So it's your contention that people would come to the state of Connecticut, apply to the probate court, and stay in Connecticut long enough to go through the probate court process.
Yes, absolutely. We already know that parents go online and they Google, where can I marry off my 14-year-old, 15-year-old, 16-year-old?
And you don't believe that our probate court judges might look at this and say, hey, this is, an out-of-state child, an out-of-state parent making this application. You don't think that that would raise a red flag with a probate judge?
I can't speak to that. It's not my area of expertise.
But you're saying it's an emergency. You're saying that this will become a child marriage destination state.
Mhm.
So I'm going to push you a little bit on that. Don't you think that our probate judges might understand that that's a red flag situation?
I don't believe there's any screening process in place that can 100% prevent forced marriages, unfortunately.
Thank you. Thank you, Mr. Chair.
Further questions or comments? Seeing none, thanks for being with us.
Thank you so much.
Next up will be Gia Cook. Gia Cook with us.
Hello, sorry. Can you hear me?
Yep.
Okay. Thank you. So to dear chairs Winfield and Staffstrom, vice chairs Flexer and Quinn, and ranking members Kissel and Fishbein, and members of the judiciary. My name is Gia Cook. I'm a first year in college and I'm a resident of New Haven. I'm here to communicate my strong support for House Bill 6569, an act concerning the minimum age to be eligible to marry. Currently, 7 states have set the minimum age for marriage at 18 and eliminated all exceptions because they recognize the danger that child marriage poses and took concrete action to protect the children of their states. And I think it's time for Connecticut to do the same. Child marriage can easily translate to forced marriage, as you've just heard, because the age of majority is 18 or above in every US state. And when children have these limited legal rights, it can trap them in marriages. And there's a myriad of evidence that shows how harmful child marriage is to these children. Individuals in the US who were married before 18 report high rates of physical, sexual, financial, emotional abuse during their marriage, as well as unwanted and unplanned pregnancies. And this dismal situation is even further exacerbated for teen mothers, as teen mothers who marry and then divorce are more likely to suffer economic hardship and instability than teen mothers who stay single. And marriage before 18 has a 70 to 80% divorce rate. Child marriage is extremely harmful, and I believe that it needs to be eradicated. And this issue is very important to me personally because I've seen the effects firsthand. Before my grandmother passed away this past November, I lived with my grandparents my entire life. They'd gotten married in the early 70s, and my grandma was 16, but my grandpa was almost 19. She always used to say that it was the biggest mistake of her life, and she urged me to be cautious. They got married in the backyard of my grandparents' house, or my grandpa's house, sorry. It was his parents' house. And at 16, she hadn't even had her first job yet. He worked and provided for them, so she was completely financially dependent on him. And even once she got a small job, she still didn't have enough money to make it on her own. So when he became physically abusive, she felt that she had no way of leaving. She was essentially trapped. And then when she became pregnant with my mom, the situation was even worse because now she had a child to consider, keeping in mind that at this point, she was still very young herself. I often imagine how different her life would have been if she hadn't been stuck with my grandpa, because I love her so much and it just hurts to think about how much she suffered in her life. So I don't think anyone should have to go through that. But currently, the law in Connecticut does not completely protect the children in this state from the same fate. So just to reiterate, I really do urge you to help protect other children from these unsafe and damaging marriages. And I believe that we need to follow in the footsteps of the 7 states who set the minimum age for marriage at 18 with no exceptions. I urge you to favorably vote this bill out of the Judiciary Committee so that the children of Connecticut are properly protected, because I don't think young lives should be permanently altered by marriages that they're not ready for. That was all. Thank you for your time and consideration.
Thank you. Questions from the committee? Seeing none, appreciate you being with us and sharing your story. Next up will be Bridget Kostner.
Good morning or good afternoon now to the honorable and distinguished members of the Judiciary Committee. My name is Bridget Kessner, and I'm the policy manager with the Connecticut Alliance to End Sexual Violence, the statewide coalition of sexual assault crisis centers providing 24/7 support to victims, legal services, and post-conviction programs. I'm speaking in strong support of HB 6569. The legal age to be married should be 18 without exception. There are gaping loopholes in the 2017 marriage law. 95% of the minors married in Connecticut before 2017 were 16 or 17. And so this law actually only ended 5% of these marriages. It did not and has not protected the vast majority of minors impacted by child marriage. It must be urgently revisited. This is urgent because one child victimized is one too many. Alarmingly, 83% of the time, these are minor girls wed to adult men. I hope we can all acknowledge that there's a clear power dynamic and a high risk of abuse and sexual assault when a high school aged girl is expected to marry an adult man. High schoolers cannot relate to an adult's financial and social power and independence. Also, if an adult does not care that the young spouse may not have truly and freely entered into the marriage, it's hard to imagine they would then care about consent to sex or reproductive rights. The potential for grooming must also be considered, given the age differences and power dynamics at play. If married minors are abused, accessing shelters, legal support, and divorce are often complicated and unavailable because the victim is not an adult. This is further complicated when they're not financially independent. We are leaving these minors at high risk of harm while also leaving them highly isolated and with less access to help. With respect to earlier questions about divorce and criminal processes, based on my knowledge of victimization and reporting dynamics, it is worth noting that youth married since 2017 very well may not yet have the necessary financial resources, knowledge, or support to access these logistically and emotionally difficult legal processes. I believe in amplifying victim and survivor voices, and so I encourage you to refer to my written testimony, which links to stories from victims with various cultures, religions, and experiences. And I'd like to sincerely thank every victim and survivor of child marriage who's come forward to make a change. I also want to acknowledge that victims do have privacy rights and that we cannot rely on victims disclosing the traumatic details of their stories in order to create protections for them. That's why we have advocates like myself. Please feel free to contact me with any questions and refer to my written testimony for more information. Thank you so much for your time and attention to this urgently important matter.
Questions from the committee? Representative Fishbein.
Thank you, Mr. Chairman. I've asked a lot of people here today about facts of one of the 31 cases or instances that this marriage has been approved by the probate court since October 1, 2017. Do you have any facts of any of those cases?
Respectfully, as a certified rape crisis counselor and a confidential resource, I would not be able to disclose any information.
I didn't ask you for the information. I asked you if you had any of the facts.
Again, I can't confirm or deny that I have information about these cases specifically, but
confidentiality doesn't extend to whether or not you possess information. It's the information. So am I to understand that in the context of your employment or volunteer activities that you have specific facts with regard to any of these post October 1, 2017 marriages that you're here talking about here today?
personally, I have not had any of those cases under my direct purview.
Okay. So are you aware of the current requirements to get married in Connecticut if you're 16 or 17?
Yes.
Okay. And I voted for those. I
Yes.
voted, we all voted unanimously for them. Where is the loophole?
So for individuals who are either emancipated, again, by their own will or the will of their parent, or for individuals that are given that approval, the judicial approval, again, based on the support of one or more parent.
So you're saying the entirety of the current process is a loophole? Loophole
For
is usually something that you're able to slither through that was not the intention of the legislature. So where is that? What particular portion of this statute makes it so that it wasn't the intention? It does something different, the loophole.
Yeah, no, I appreciate that question. I think the loophole in this situation is that there's a high possibility, propensity, and actuality of those exceptions being abused by people who are coerced into emancipation, who are still forced into these situations. And while that legislation was an important step, ensuring that the marriage age is 18 ensures that those exceptions cannot be abused, considering the significant harm that that abuse creates.
Well, that doesn't jive because that can happen to a 19-year-old, right? A 19-year-old could be improperly coerced into entering into a marriage.
They would still have the liberty of having the ability to decide in a way that somebody who is younger would not. If a child is talking to a judge and realizes that if they reveal what's going on in that moment, they're not going to have food, they're not going to have a place to live, and they could be subject to physical abuse from their family. That's a significant difference than somebody who's 19 and feels a level of social or familial pressure into entering into a marriage.
Well, I gotta tell you, it doesn't make any sense at all. And with all due respect, let's just say that somebody's birthday is December 21. December 21. You're telling me that on December 20th, because the probate court is the gatekeeper to this marriage happening, there's somebody in the way that has to give permission, that on December 22, that person who has no protections is better off.
I think it should be acknowledged that they have other rights as an adult at that point in time, as my colleagues have discussed, and that would put them in a better place should they need help in the future. They would have a better chance at being able to access services, to access help in a way that they would not have when they were younger.
But if both individuals are being improperly coerced into entering into this marriage, I fully believe that the 18 or the 17-year-old has more protections than the 19-year-old, because the 17-year-old needs the permission of a third party who is required to go through a statute and determine, there's no coercion, that it's not harmful to the individual. The 18 or 19-year-old has no such protections.
Given that the minor does not have the same agency that older person does, I respectfully disagree that they are just as protected.
Agency in what in what perspective?
Again, as I had stated and my colleague shared, these could be individuals that really don't have a choice if they want to continue to eat and have a roof over their head, right? These are individuals who are potentially in a position where they are not wanting to necessarily be emancipated, but that's their parents' choice is to petition on their behalf, right? So there's a lack of agency there that would not exist if they were 18 years old.
I'll tell you that statistically, there are more 18, 19, 20-year-olds in this state living at home with their parents than there were 20 years ago. So they have the same, while one class has the ability to contract, they both have the same level of potential coercion, a roof over your head, food on the table, that kind of stuff. So I'm trying to, we have these representations, not only you said there were gaping loopholes in the current statute, and I'm trying to see a loophole and then try to get to gaping, and I don't know.
I think, well, I can appreciate that people are staying home longer than they once did. I think that we need to acknowledge that those are individuals that, should they want to leave, should they be forced out, there is not going to be the same state involvement. And again, should they want to leave, they're not going to be then driven back to that house. So I do think that even though they are still at home, they're not in the same position that a minor living at home would be in terms of their dependence.
But a 17-year-old who's kicked out of the home and somebody understands that happens, there's going to be police intervention, there's going to be DCF intervention, all of that stuff. The 19-year-old, given the same impact, you're not going to have any of that stuff. So once again, I think that the minor here is of a greater level of protection, but thank you, Mr. Chairman.
Any further questions or comments? Seeing none, thanks for being with us.
Thank you.
Andy Zaveris.
Good afternoon. Thank you, Chairman Staffstrom and members of the committee. It's my pleasure to be testifying in front of you guys again this year. I testified on behalf of House Bill 6570 last year and felt like I was preaching to the choir, and I feel that way now. One of the benefits of going towards the end today is I was able to listen to a lot of the testimony that was provided already, and A lot of it was covered, what I was going to say, but there are a few things I feel like I need to sort of clarify. One of the things that this bill is seeking to do, the only thing really that it's seeking to do, is to take away immunity from towns and municipalities in these municipal motor vehicle cases. Again, as been stated many times before today, we want the municipal actors to be held as responsible as a state actor under a similar circumstance. And that's all we're seeking to do. To the extent that it was alluded to earlier that 14283, which is in the motor vehicle statutes, provides municipalities some type of immunity already if it's an emergency vehicle responding to in an emergency call, that's just not true. 14283 is not an immunity bill. It's not an immunity statute. All it does is it says that in certain situations, a municipal vehicle that's operated by a municipal employee or a state vehicle operated by a state employee has certain liberties it can take advantage of when responding to such a call. In other words, if it needs to go faster than the posted speed limit, it can do it if it can do it safely. If it needs to run a red light, it can do it if it can do it safely. Whatever the particular function of operating a motor vehicle that they can exceed and do it in a safe manner, they're allowed to do it. It's sort of this balancing test that was referred to before. So, and to the extent that there was some confusion earlier about which vehicles are covered by 14283, the definition of emergency vehicle right in the statute is very clear. It covers any ambulance. It covers any vehicle used by a fire department. It covers any, and this it says specifically, any state or local police vehicle operated by a police officer. And finally, it talks about vehicles operated by the Department of Corrections. So it includes both state and municipal vehicles explicitly in the definition of emergency vehicle. And the only thing it says is, yeah, you can go faster than you need to. You can run a red light if you need to. Just do it safely. And that's really the analysis that has been going on since I've been a lawyer, and I started practicing in 1992. And it's only been in the last 4 or 5 years that we've been seeing towns and municipalities raising immunity as a defense in these types of cases. It was never something that was contemplated before.
That was the bell.
Okay, I'm sorry, but I'm happy to take any questions.
Questions or comments from the committee? Questions or comments? Seeing none. Always good to see you. Thanks for being with us.
Good to see you too. Thank you.
Michael Rigg.
Good afternoon. My name is Michael Rigg. I represent I'm here on behalf of the Connecticut Dermatology and Dermatologic Society, the Connecticut Urology Society, ENT Society, and the Connecticut Society of Eye Physicians. I'm licensed to practice law in the state of Connecticut. I'm here to speak in opposition to House Bill 6739, an act creating a state cause of action for the unauthorized disclosure of protected health information in violation of the Federal Health Insurance Portability and Accountability Act, frequently referred to as HIPAA. HIPAA is actually a series of federal regulations, privacy regulations. It's established under federal law that there is no right to sue for a violation of HIPAA. So this bill seeks to create what appears to be strict liability if there is even a technical violation of HIPAA by a healthcare professional. There would be an ability to sue. And this appears to be in addition to the Supreme Court's decision in a case called Byrne versus Avery Center, which already established a right to sue a healthcare professional for improperly disclosing protected health information. The addition is that a plaintiff can also recover attorney's fees and costs and doesn't seem to have to establish any kind of fault. The real reason for our opposition is that this is going to be highly detrimental to the judicial system. Because at the moment, HIPAA does apply to subpoenas and orders issued by state judges. And so what this bill effectively does is it says that if somebody is dissatisfied with a court decision in which their protected health information has to be disclosed pursuant to a subpoena or a court order, they can still sue the healthcare professional. And that is going to have a significant chilling effect on the willingness of healthcare professionals to comply with subpoenas and to cooperate with criminal prosecutors and the Attorney General's office that is investigating child abuse cases. They will be very reluctant to cooperate, and instead they'll be hiring people like me, which I already have a busy practice involving subpoenas that are issued to healthcare entities like hospitals. And instead we'll have to simply oppose prosecutors and attorneys generals who try to obtain information necessary to their court cases. So for example, right now I'm defending a hospital that is currently being sued by a person who was convicted of serious crimes.
So that's the bill. I have a question for you. So is it your testimony that complying with a subpoena currently is not a violation of HIPAA?
It could be a violation of HIPAA, yes.
So complying with a subpoena could be a HIPAA violation?
Yep. Yes.
Okay, do you have a case or a cite on that?
Yes, I do. La Cava versus State of Connecticut. That in that case, it was a superior court, and it was a case that was cited favorably in the Byrne Supreme Court decision. And in that case, there was a subpoena that was issued to a hospital, and the Superior Court ruled that HIPAA preempted a state statute that allowed the hospital to send the medical records directly to court in a sealed envelope. Said it was preempted. The Byrne case cited that decision favorably, in which in Byrne that involved a subpoena as well, and that HIPAA does apply to subpoenas. So yes, you absolutely can be sued, and you are, and they are being sued for complying with subpoenas.
Wasn't the issue there, correct me if I'm wrong, but wasn't the issue there not that the documents were sent, but it was that the patient wasn't notified that the documents had been sent?
Yeah, in violation of HIPAA. So apparently the lawyer who issued the subpoena didn't notify his opponent, and the group sent the medical records directly to the probate court, and the clerk of the probate court put the records in the public file. And then this involved a case between an estranged couple. And so it was the boyfriend's attorney who had issued the subpoena for her medical records. She was the patient of the group. And he went to the probate court, and because the clerk had placed the medical records in the public file, he was able to view her medical records. That's what had happened. But the records were sent in response to a subpoena that was issued by the boyfriend's lawyer. Now, the medical group did not comply with the face of the subpoena, because the subpoena had actually commanded the group to go directly to the lawyer and provide the records directly to the lawyer, which they didn't do. But that left open a question that I know I'm currently litigating as to, in a case that I have, where a hospital and a doctor and nurse are being sued for cooperating with a criminal prosecution. So far, we haven't been able to get the case dismissed, but we think that based upon the Connecticut rule that protects witnesses from being sued for complying with court orders, that ought to apply to healthcare professionals as well. That hasn't been decided yet, however. But this bill would eliminate that. It would say even, that even if you comply with a subpoena or even a judge's order, you could still be sued. Because if the judge's order is not HIPAA compliant, well, then the claim would be that the healthcare professional should have challenged it and shouldn't have complied with it.
Yeah, I'm not sure I'm buying it. I mean, I think what I just heard you say is as long as you comply with the subpoena the appropriate way and you notify folks and you provide the documents in the order in which they're requested, which is HIPAA compliant, then there's no issue.
Well, that's the issue. Is it HIPAA compliant? So in other words, what happens is the burden falls upon the healthcare professional as opposed to the legal profession or the courts. So if a judge issues a court order that somebody thinks didn't comply with HIPAA, it's the doctor who gets sued. If the lawyer issues a subpoena that doesn't comply with HIPAA, it's the doctor that gets sued. Under Connecticut common law, the rule is that the witness is not obligated to litigate that. Now, there could be a HIPAA violation, but there's no basis to sue under Connecticut law. You're not allowed to sue. And it's important to keep in mind that HIPAA itself, the federal government did not seek to create a basis of strict liability for doctors and hospitals because the HIPAA privacy regulations don't create a cause of action. So what this bill does is it creates a cause of action that essentially imposes strict liability on a very complex web of privacy regulations that the average person, in fact, in my experience, the vast majority of attorneys do not understand.
Further questions from committee? Representative Fishbein.
Thank you, Mr. Chairman. So perhaps as a way of dealing with the disclosure, we could put in place something like we do with banking records, the 10-day rule. There has to be notice to the provider that the patient had the opportunity to object and all of that stuff. But moving forward, the problem is publishing. Information comes into the care of a medical provider and it is supposed to be confidential. So presently, if someone is diagnosed bipolar and a doctor takes out an ad in the newspaper and says, I was going to say my name, but someone is bipolar. As far as I understand the law, the individual who is harmed can't sue the doctor for violation of HIPAA.
That's not true.
Well, okay. So is that the new Supreme Court case like 3 years ago?
Yeah, it was 2014 is when it came out.
So at least prior to that, and I've got to go back and look at that, the AG's office was the only one who could bring the action and the money would go to the general fund. I guess my concern with the language before us is, in my scenario, how does one prove damages? I mean, that would be a violation of HIPAA, publishing protected medical information. It's in the public sphere. But this law calls for damages. So
that's existing.
Calculate that.
Yeah, that's existing law. So in the Byrne case, the jury awarded this lady, the patient, $855,000. They had no trouble figuring out what the non-economic damage were to be awarded. And so in your hypothetical, it would apply exactly as it did in the Byrne case, in the Byrne trial. Your medical information has been published in a very inappropriate way in a newspaper in this hypothetical. Of course, the doctor would be sued and can be sued under Connecticut state law. So this bill isn't addressing like something that Connecticut law doesn't already address. I mean, perhaps there should be a law that allows lawyers to be sued for doing this kind of thing, for issuing subpoenas and obtaining medical information that they shouldn't get, or disseminating medical information that they shouldn't be disseminating. Like, for example, in the recent case involving the Sandy Hook parents, there was an attorney, he's been disciplined for disclosing protected health information that he got. But under Connecticut state law, he can't be sued. Even though the judge found that his conduct was reprehensible in disclosing that protected health information under Connecticut law, he's protected from being sued. But yet we're not going to extend that same, or this bill would eliminate the protection. Let's say if I change that slightly and it was that same lawyer obtained the information from a doctor's office and then he improperly disclosed it, well, he's protected, but the doctor's office isn't, if this bill were to become law. And that doesn't make any sense.
Well, I certainly appreciate the distinction, and I do recognize that. And I mean, I guess that's a function of the feds, in that they don't have the chain of receipt of the documents or information be protected at the same level as the source. But you said this is existing law. Is it existing case law, or it's existing statutory law?
It's existing case law. So it was the Byrne case that first established that there was a common law duty of care that was owed by doctors to their patients to keep patient information confidential. And then if that duty of care was breached, they can be sued. And then the Supreme Court also further held that in determining whether the disclosure was not appropriate, a plaintiff can rely upon the standards published by HIPAA. But, to the extent that that would establish negligence. But this bill, and I don't know if you've read HIPAA, it would take you many weeks to read it all. It's a very complex web of regulations and exceptions. And so this bill essentially imposes strict liability on doctors and other healthcare entities that certainly wasn't intended by Congress or by the federal government, because again, they made it very clear that enforcement of HIPAA was going to be done by the Department of Health and Human Services. It can also be done by the Connecticut Department of Public Health. Now, certainly, if there's a breach of the common law duty that's owed by physicians to patients, the Supreme Court has said, yes, there can be liability, and there was a significant jury verdict against that medical practice for sending the records to court. Now, what wasn't discussed in the case, because I don't believe it was ever raised, was, and it may not have applied in that case, but the idea of the long-standing rule that witnesses to judicial proceedings, whether it's a criminal case or a civil case, that they shouldn't be sued for money damages, even if there was a disclosure that was not appropriate, so long as they did so in response to a subpoena or a line of questioning, in a court proceeding. So I'm right now there is a case going on where it is a former criminal defendant who was convicted, who is so far been permitted to sue a hospital that cooperated with a criminal prosecutor who brought somebody to justice in part because of the information that they obtained from the healthcare professional. Now, we don't believe that there is any kind of HIPAA violation, but you see, if you have to hire lawyers to litigate these things, that's the chilling effect that the Supreme Court has identified. It's, to say, well, don't worry, you'll eventually win when you're getting belted with lots of lawsuits, because it's no secret that hospitals and healthcare professionals are frequently subpoenaed because they have information that's often highly relevant to personal injury lawsuits, to criminal cases, to child custody disputes. And all of these are very contentious, or many of them are very contentious. So it would be no surprise if a party disappointed with what occurred decided to take it out on the doctor or health practice or hospital after perhaps losing in the underlying case, which is what happened in like I've said, I've got a criminal or a former criminal defendant pursuing this so far. So to say, well, don't worry, you can just litigate these cases and bleed attorneys' fees is very cold comfort. And certainly my advice to clients would be, well, we'll have to litigate the subpoena or the court order. We'll have to appeal and say, we think that there's a chance that this doesn't comply with HIPAA. And so we need rulings from the Connecticut Supreme Court in every single case. That's what I will do.
Or we need to tighten up the statutes, because what I've heard is that let's say 2014 or so, this private right of action didn't exist, but the Supreme Court, I believe in the Burns case, created this right. And I think what we're trying to do here is to codify what was represented or recognized by the Supreme Court. So I don't want to belabor this, but how does this different from what the Supreme Court has said is a right? How does the language before us differ?
Well, the right has to emanate from state law, Connecticut state law, not HIPAA. HIPAA is a very technical set of regulations. So, you know, it's certainly common practice for the agencies that enforce HIPAA to only enforce it when somebody didn't have a good faith interpretation of HIPAA, but there may have been a technical misreading of it. But this would create strict liability. And as I said, because HIPAA applies to state court proceedings, that means it creates liability. If this bill as written goes through, it will, which is something that the federal government did not intend, to create to create liability for money damages, even when, you know, somebody's responding to a subpoena. There could be, and I'm sure sometimes there are, mistakes made by healthcare entities and by prosecutors and by attorneys at the Attorney General's office and by private attorneys regarding subpoenas and court orders and things like that. Like, just to give you one example, you know, HIPAA says that a court order must specify only the relevant information, you know, the information that's relevant to the lawsuit. I've got to tell you, I don't think I've seen a court order that does that. So now I have to say, oh, I'm sorry, Judge, I don't think that your court order like technically complies with HIPAA. And these are often situations, they need the information like fast. They need it, you know, immediately, and they're not able to quite do it correctly. So somebody like me has to say, I'm sorry, but I don't want my client to get sued. And what this bill does is it adds on, you know, I mean, it appears to be an attempt to create it, to make it more attractive for lawyers to sue because they can now recover their attorney's fees. Well, I think you'll be successful in that. I think there'll be a lot more lawsuits than and there's been quite a lot in the wake of Byrne. So certainly there needs to be, in my view, at least the continued protection under what's known as Connecticut's litigation privilege. Because you're just going to be bringing the judicial system to its knees, because people like me are going to say, I'm sorry, but I'm not going to let my client expose itself to future civil liability by complying with your subpoena in your criminal case or your civil case. I mean, it's already become very difficult in a lot of these cases when, you know, I mean, just on Friday, I got a subpoena from the Attorney General's office, you know, needing to litigate a child custody matter, you know, that involved the Department of Children and Families. And their, you know, order that they obtained had some typos in it and didn't quite comply. And so what this will do is just add on numerous layers to say, no, I need to litigate this and prevent any kind of disclosures in order to protect my client from future lawsuits that allow them to get hit for attorney's fees. Because even if the damages are de minimis, now there can be an award of attorney's fees, which are, could be really substantial. And people will be looking to squeeze out settlements for healthcare entities that are just trying to comply with subpoenas issued by lawyers and court orders.
All right, thank you.
Further questions or comments? If not, thanks for being with us.
Thank you very much.
All right, we had two folks who were missed. We had Magdalena Corman, we'll call again, and Mary Carmen Aparicio. Hearing none, we will declare this public hearing closed. Have a great day, everybody. Stay safe. Enjoy a little bit of snow tonight, and we will see you again Wednesday.